Probably there's some urgency in the matter.
My lord, item 50 of today's daily list. Yesterday was the returnable date. Kindly take this up matter today. Today it is running as item 50 of your loss list. The trial court date is tomorrow, that is Saturday.
Tomorrow
on
for
the-
what?
Tomorrow for argument as last chance in the trial court.
What
On
is the order impugned?
The order impugned was that my section 5 application was allowed in a miscase which is filed for a order 9 rule 13 application. On the last occasion, after hearing this, court had directed to mention the matter if it was not taken up yesterday, that which was the returnable date. Affidavit of service is
Who is
ready.
appealing for the other side?
There is no advocate who is appearing for the other side.
Have you served upon the other side?
Lordship.
About a 50.
To mention one,
Yes.
Lordship, two matter which appearing monthly list. The OP is appearing Shaunak Bhattacharya. It is for release.
Inclusion in the list.
Inclusion motion. Inclusion motions, please hand over the slip. Upgradation, please hand over the slip. Mention with the artist.
Extension of interim order.
When it is expiring.
My lord, it will be expired on 23rd of July. Thank you, my lord.
A matter was mentioned on Wednesday with regard to matters which have been released by my lord. This is an application in a civil revisional application where the original application was released by my lord. My lord, the issue is, my lord, there is another matter which is pending which has been assigned before another bench. If my lord, this is only for release, if it can be taken because my lord is not there
So
for
it is not appearing
in the list, my lord. Civil revision was released by my lord.
Supplementary extension.
Well, may I be
1 p.m. Please come at 1.
well, may I be permitted to mention one disposed of matter, my lord? I find there is a typographical mistake.
My lord.
Let it appear as to be mentioned.
My lord, typographical. What is the typographical?
My lord, instead of 6th gem, it has gone down as 2nd gem.
Instead of
6th judicial magistrate, it has gone down as 2nd judicial magistrate.
আজকে দেখিয়ে দিন তো সাপ্লিমেন্টারিতে
এই অর্ডারটা দিয়ে দিচ্ছি।
সাপ্লিমেন্টারিতে দেখিয়ে দিন
All right, in the last portion
সাপ্লিমেন্টারিতে দেখিয়ে দেবেন আসুন
only that
will be 6.
Yes, in the first
paragraph it is yes. It has
Your unavoidable circumstances, my lord, I am praying for leave to, my lord, move and matter for the circuit bench of Jalpaiguri, my lord. My lord, yes.
leave that. Yes.
But one thing, my lord,
serve upon the respondents there.
My lord, this is a repeat civil revision, my lord.
Civil revision.
Civil revision.
Civil revision, Jalpaiguri, I do not have determination.
My lord, this.
I do not have determination. Civil revision, Jalpaiguri. Yes, call the list.
Time for the petition.
Time for the response.
Accordingly, the notice of cancel.
Obliged, my lord. And for the state.
Nanda. But I appear for the petitioner. No, this matter was mentioned for your lordship to be taken up by your lordship. I don't know why it has come as to release. Because
Yes.
I think the respondent mentioned, Mr. Shah.
If I may indicate, my lords, whereas the arguments had been concluded on behalf of the petitioner, they'd been concluded, and there's a direction from the Supreme Court also for expeditious disposal. In fact, your lordship
No,
sees
not
the
of
last
this
two-
227.
No, of this as well, my lords.
Sure.
This I have a
Not
copy
of
of
this
the
227
I have a
expeditious.
copy of this order, my lord.
It was heard by.
No, arguments,
We have made our argument supplementary affidavit filed by us.
substantial arguments have been made. So if the
My lord,
bench,
Mr. Shah is there.
my lord, no difficulty, my lord. It's up to your lordship. If your lordship wants to take it up, we are very happy. If your lordship wants to release it, only request
because
is
Mr. Shah, if the substantial arguments have been advanced,
yes, that's
I
correct,
think
my lord.
it's better that.
Yes, my lord.
that
Only
way.
thing is, my lord, there was an understanding between the parties before the my lord learned other my lord bench that next date is 28th. We will, my lord, both pray for an adjournment on the date. Next date.
That is recorded in the order.
That's
That's
it
recorded
has been
in the order.
it has been submitted.
My
You are
lord,
for
with that
the
understanding, my lord, it may be released.
you are for the opposite party.
Yes, my lords.
The
Opposite
learned
party is
advo-
1 to 4.
The learned advocate.
Grateful.
Lordship, we have to release the matter. Otherwise, that will be assigned. Lordship, we go out of the list.
Release
Release
take
the
the matters from the list. of
Yes. No matter that understanding between the parties that both sides will pray for.
the- When I'm releasing,
I know. But that's the understanding between advocates.
yes, it's
My lord,
between
my learned
both of
friend is
you.
there. I'm sure, my lord, my learned friend will
Gentleman's
know that.
argument,
Yes.
agreement.
In
more
court,
so is the learned
definitely.
advocate's agreement.
Yes.
Definitely.
Yes.
opposite party বলছি স্যার petitioner in person স্যার এটা
The opposite party. So Gopal Ghosh is appearing. Where is
নোটিশ
he?
স্যার সার্ভ করা হয়েছিল মেনশনিং এর আগে
Passing it over. Pass over. Ask Mr. Ghosh to come. So Gopal Ghosh, ask him to come. Pass over. Yes, next.
I'm for the petitioner, my lord.
Yes. এটা কি হলো? Two mention কেন? আগেরটার মতো সেম অর্ডার।
It's appear for the petition number.
Yes, Mr. Bordon.
Somehow we've been able to reach a consensus.
Lord, I tell your lordship what my suggestion is. Without recording my concession, your lordship can pass this order. My lord can set aside the order under a challenge. Direct lord the tribunal to decide the issue with regard to declaration of NPA. And lord, in so far as the
In the earlier matter, which stood.
in the earlier matter, because lord, the other matter is not under challenge before your lordship.
Yes.
I would have been very happy if the second matter had been sent back. But lord, there is
What will happen to the second matter then?
second matter he has filed upon rejection of the review. That is the main.
No, it's the other way around.
Other way around. Okay. Now, in the second matter, no,
That is this matter. Review rejection is this matter.
so therefore,
Thereafter, he has challenged the subsequent.
and
yes.
there they have held that it is res judicata because this point has been decided.
Yes.
Now, your lordship can make an observation that without giving any weightage to that order, the main matter can be decided. This is because he has not preferred a second application, my lord, under 227. So this is the way I thought that is the best.
My lord, I am agreeable to anything provided, my lord, I am protected till that time.
And my
Let
lord,
them not act on the orders under section 14. Till that time.
shortest possible time be fixed for the purpose of deciding this issue.
Section 14, what is the date?
My lord, section 14, the order has been passed, my lord. The last date was 9th.
So my lord's order is the last order that my lord passed.
The interim
My
order
lord-
is still today.
My lord is has protected. Let us-
That today.
that protection continue till the matter is decided.
Till that, my lord, the second essay is decided, my lord.
Without giving weightage to the subsequent order, let the issue be decided independently. That observation can come from my lord.
Mr. Bordon, where is the impugned order?
Yes.
My lord, the impugned order is the order, my lord, dated 16th of June 2026. My lord, this would be volume 2.
It's
Yes.
not paginated.
Oh,
The last.
sorry,
It's the
certified copy.
certified copy,
Yes, my lord.
but certified copy in the middle, thereafter you have annexed
My lord,
something.
we could not do this is what they have given. My lord, for locating the, my lord, for showing certain orders to you, my lord, I had applied for the entire order sheets. Now this is the way.
You could have applied in two sets, orders and those petitions and other things.
My lord, I appreciate
Comes in the
Very
middle. If your lordship's lord kindly take.
So the impugned order is 16th June 2026.
Yes.
16th June 2026.
It comes in the middle.
So this is the review application.
Yes.
Yes.
Alleging that
The court has not
you made
considered.
some submissions,
Yes.
but that was not considered.
Absolutely.
And
But in fact, his contention, he has annexed his written notes, which your lordships will find at page 51.
51 first volume.
Yes.
Only one thing, Mr. Bordon, please show me that finding in 16th June with regard to dealing that you have made submissions. Where is that?
That I have not met submissions.
Yeah, according to you, you have made submissions. Court did not accept that.
Yes.
Where is
My lord,
that?
my lord, kindly sees, my lord, internal
Paragraph
page 3,
20.
paragraph 7.
Paragraph 7.
7 at internal page 3, my lord.
Did not press. Yes, and the last is paragraph 20.
And my lord, the last would be paragraph 20, my lord.
All right. So this was, and where is this? This is review.
This is
Where is
review,
the original order?
my lord, the parent order would be, my lord, the order prior thereto.
16th.
This is 22nd of November 2023.
Previous page
Previous page.
or the previous document?
I'll just take a moment of I'll just take a moment, my lord.
That is, my lord, page 150 to 157.
Is it 22nd November 2023?
Yes.
So 22nd November 2023, that order was in your favor in other aspects excepting one.
Yes, essay was allowed.
Please show me that.
My lord, I'll show that, my lord, kindly.
What were the, yes, demand notice was set aside
Yes, my lord, kindly sees.
and may issue fresh demand.
Lord,
Yes.
kindly see page 4. Your lordships may kindly see page 4 of that order.
Yes.
Kindly come to the third paragraph.
Yes.
Says upon receipt of the plaint, the aforesaid proceedings filed so and so as a counterblast, defendant bank issued so and so 13-2, declassifying the account as NPA. Has your lordship found that?
Yes, yes.
This, after recording that, then Lord, the court proceeds to record the submission that the demand notice is bad because Lord, the breakup of the claim has not been given. And ultimately, Lord, sets aside the demand notice.
That would be, my lord, page 8.
Yes, but nothing with regard to NPA.
NPA, nothing has been, Lord.
So he's aggrieved by that.
I could have taken a point that this is a factual finding in the review application, therefore 227 does not lie. But not just to shorten the litigation, because Lord, the matter may not end here, he may go up. Kindly see the scope of the adjudication. That's why, Lord, I also want your lordship to kindly have a look at, Lord, the point that he has raised at page 52.
50 in the civil revision application.
Civil revision application, page 52, his written notes of argument that he's claimed to have filed. This is the only point in issue. That's why I thought, Lord, it is to shorten the litigation, it is better.
Yes, because that issue goes to the root of the...
Kindly, my lord, come to page 52. I'll just show your lordship. Kindly see the second paragraph at page 52. Has your lordship found that? Page 52.
Yes, page 52 is a longish paragraph.
Yes, kindly see the kindly come down at 1, 2, 3, 4, 5, 6, 7th line. The bank statement.
From the top, the bank statement, yes.
of the relevant account, so and so affidavit depicts that the balance in the said account exceeded the limits as on 31st January 2018. In view thereof, the account could have been classified as NPA after 1st May 2018. Since 1st May 2018 is the 90th day since the said account exceeded the sanction limit.
So this is his challenge.
This is the only challenge. He says that you could have declared it on 2nd May, not on 1st May. This is the scope of challenge of NPA. This is the only point, and he says that this is on the basis of a prudential norms or the circular of the Reserve Bank.
This was not considered
According to him. According to him, the court says that he has never pressed this point. But be that as it may, I'm saying that kindly give him the credit of having argued this point.
No, my lord, not credit, my lord. There's a recording by the learned judge in the court.
Don't go by that. Where is your surface application?
My surface application at page 24.
24.
Yes.
Please show me the prayers.
Prayers would be, my lord, at page 45.
45. So quashing 13 cancelling replies.
My lord, see page 47.
40.
In fact, my lord, see page my lord, 46E, right at the top, my lord.
46.
Right at the top, my lord, running page 23.
Declaring. Yes, page 46. Yes. And where is that next section 14? Have we annexed it here?
Yes, yes. The section 14 orders, my lord, others page 136 and page 139.
136.
And 139, volume 2.
You have challenged that.
Well, those I had challenged, my lord, in the second surface application.
Yes,
Now, the court
that-
said res judicata, nothing.
Where is that order?
Well, those orders would be, my lord, at page 144.
146 it starts. 7th April.
144.
So, two order 144 and 146.
146 is the last order. Your lordship can look at that order.
But that's based on the page 144 order, my lord.
146.
Well, two orders challenging, my lord, two section 14 applic orders.
Yes.
Since, my lord, there were two sets of
146.
144. I don't think, Lord, the civil revision is against this order.
No.
It's
So civil
against the order
revision
of
is-
146 at page 146. 7th April 2022.
Only one thing, Mr. Bordon, that is what it was passing through my mind. That what will happen to this order?
I tell you
Because-
that this order need not be touched because, Lord, his only unhappiness at this stage is that my prayer for declaration of NPA being bad is not considered. So, Lord, I am saying that only
Let it be reconsidered.
reconsidered, there is no difficulty.
Yes.
He has not got an interim order in the second application. He is
Because
not
ground is this.
no.
kindly see page 145. What is the ground? What weighs in the mind of the judge? Page 145, my lord, the third last paragraph.
Has no interim order can be passed.
Because I have preferred review
No,
of judge.
Mr. Bordon, as Mr. Kaur has said, I have protected you for a limited period. I am granting that protection. I am not saying anything with regard to the
Yes, my lord.
second order.
I have no problems, my lord. As long as the
Your
protector,
lordship can come back and decide the matter also. My lord, I don't mind, my lord, going into the merits
No, because only
because
one
it's
thing.
a factual finding by a court in a review application saying that
I'm not going to that. Let the tribunal decide that because it's an issue has to be decided for
that
the
is-
first time by the
I don't mind. That's what I said at the initial stage that I don't mind this NPA issue being decided.
The other thing is that Mr. Kaur and Mr. Bordon, can an effective order be passed in to be mentioned?
of course,
Because
on
sometimes some
No, because-
objections are being raised.
Because the matter was
Posted
fixed
consent.
yesterday at 3 o'clock. Your lordship's lord has posted it today.
can record it, my lord, by the consent of parties. My lord. We
The
propose to
matter was
dispose of.
placed today by consent of parties for hearing. That can be done. But don't record any concessions.
No. With the consent of the learned counsels for the respective
twice is a
Maybe,
coincidence.
Mr. Bordon, at times it may be difficult to recollect something because for that we have got the benefit.
But for that, holding a lawyer to ransom is not probably the right way, Malad.
Won't matter. It disposed of it. CO number such and such stands disposed of with the aforesaid observations and directions.
I'm so grateful. So grateful. Malad, a burden goes off me. So grateful, Malad.
This matter.
Seven, I appear on behalf of the petitioner, my lord. Here is the written instruction. Since they could not come, my lord, they had mailed me, my lord.
Mr. Mukherjee, please see these instructions. That one.
Yes, my lord, this is not the last order of the learned trial.
What is the order?
And since, my lord, in spite of appearance, they have not taken any steps. So ultimately, show cause was issued again. And, my lord, the witness action of the PWs already started. It's not that it's not yet, my lord, comments.
Now he says that it is to be heard prior to the witness
One
action.
application, my lord, of 2026 regarding reconsideration of 2019 application is there pending. So, my lord, your lordship can direct, my lord, that to be disposed of. That is their prayer. Because it's an interlocutory application, my lord, in any event, prior to, my lord, commencement or proceeding with the witness action, that application needs to be disposed of on merit. That's their prayer. So they do not want to press the revisional application. They just want an order by your lordship to hear out that reconsideration application on merit. Kindly record that your lordship has not gone into the merits of the matter.
Yes.
That's yes.
The petition. Yes.
I'm for the petitioner, Your Lordship. This is
For the
super declaration. Lordship, challenging the order dated 16th December, Your Lordship. But Lordship, the
Let the interim order
order
be
is
extended
expired.
because
Yes, Lordship.
Let the interim order be extended
my lord, landed senior counsel Mr. Nilanjan Bhattacharya will appear before your lordship to hear
on the prayer of the after
It was accepted, Your Lordship. Thereafter, they filed an application saying that it was not accepted in their presence, whereas they had filed their hajira in the morning. Thereafter, they chose not to appear when it was opened. Thereafter, they filed a recalling application. That recalling was allowed on the ground that they ought to have been given an opportunity to file their written objection to the report. My contention before Your Lordship was there is no scope.
they have a right to cross-examine.
They have a right to cross-examine. There is no scope for cross.
That's the only scope. There is no scope to reject that report. You only have a right to cross-examine.
my lord, I cannot
This
my lord,
interim order is continuing.
my lord, fix a short date, my lord, so that landed senior counsel Mr. Nilanjan Bhattacharya can come to argue in this matter, my lord.
After this date would have been disposed of.
Grateful, Your Lordship.
Grateful, my lord.
Yes. Yes.
Lordship, I beg to appear on behalf of the opposite party number 9, the auction purchaser.
My lord, I am appearing on behalf of the borrowers.
Yes. Interim order. Extension.
Lordship, may I only subject to Lordship. The ultimate sufferer is the auction purchaser, opposite party number 9.
Everybody is sufferer.
Let's subject to what Your Lordship is for it. I'm not saying that today matter may be heard. My only predicament, Your Lordship, I have succeeded in both the tribunals. I have purchased the property. The petitioner has lose in both the tribunals, but they are not shifting.
Strategy, who are you for?
Petition.
You are for the bank.
No, I am for the borrower. I am for the 6, 7.
You are for the borrower.
Then who is the guarantor? Guarantor petition.
So both of you are selling on the same boat.
No.
Not on the same foot.
The entire money has been paid. He is now supporting the sale. The money has been paid by me, taken by the bank, then sold to somebody else. And now he's saying that I am supporting the sale.
But the petitioner is not moving the movables from the property. I am suffering the interim order.
After hearing the
They should
Lordship, kindly, is it pleasure of your lordship to fix a date?
It's appearing in the list. Yes. So 10, what was the application for Mr. Chatterjee? Application is for extension of interim order.
There was
What is
an
the
application.
1 of 2026? Yes, yes, 11. What is the can for?
The can is for the extension of the interim order, my lord.
It expired.
No, I have filed the interim order on time and it is expired.
Yes, who is for the opposite party? Have you served upon the
Yes,
opposite
yes,
party?
my affidavit of service.
Every service filed in court today is taken on record. The
My lord, well, only one indulgence. May the affidavit of service be recorded.
every service taken on record. Yes, who is appearing? Yes.
My lord, this application is filed by the my lord petitioner defendant. My lord, this is my lord, the order passed my lord in an application for amendment. Where my lord, the amendment has been sought for my lord from cost title to my lord paragraph 19. My lord, by way of that, my lord, the nature and character of the suit, my lord, has been changed, and my lord, which amounts to withdrawal of the my lord admitted fact also. And my lord, there, my lord, the learned court below consider it as if it is a clerical mistake. If your lordship kindly consider the amendment petition, page 19, from there, my lord, lordship kindly consider, my lord, from the cost title, my lord, they want to add collector and my lord, the concerned municipality. My lord, this is not that. My lord, they are saying that, my lord, দুই দফা সম্পর্কিত পৈতৃক ওয়ারিশ মূলে প্রাপ্ত পেজ 21 প্রাপ্ত মতে দেবস্থান স্বরূপে সত্ত্ব দখলিকার আছেন পশ্চিমবঙ্গ আইনের পশ্চিমবঙ্গ স্টেট অ্যাকুইজিশন ওয়েস্টবেঙ্গল স্টেট অ্যাকুইজিশন অ্যাক্ট এন্ড ওয়েস্টবেঙ্গল ল্যান্ড রেফর্মস বিধান মতে সিলিং
At what stage this application was filed?
My lord, after my lord filing of the my lord written objection, they have filed my lord 3 applications together. Order 39 Rule 1 and this amendment petition, and also my lord an application under my lord Order 39 Rule 7. Lordship kindly consider my lord everything my lord by way
Where
of
is the application for amendment?
my lord, this is at page 19.
19.
19. আদিপক্ষ অনিচ্ছাকৃত হেতু উকিল বাবুকে ঠিকমতো বুঝাইতে পারেন নাই Lordship kindly consider Kho.
Yes.
Lord, there, my lord, পৈতৃক ওয়ারিশ সূত্রে, my lord, প্রাপ্ত মতে, that was not written. There, here, my lord, দেবস্থান স্বরূপ, my lord, they have got, my lord, they have stated. My lord, each and every para, lordship kindly consider, otherwise, my lord, I should not file this. From para 2 to 19. My lord, this is not at all a clerical mistake on the basis.
The learned advocate appearing for
My
Next.
somebody appeared in person.
Yes.
Item,
Uh,
item number 2.
Mr. Ghosh is item number.
Sir, item number 3. Sir, petitioner in person. Sir.
He is appearing in person.
Hello.
Mr. Ghosh, what do you say? What is this matter?
Lord, matter, Lord, the appeal is pending against the.
Are you ready? Are you ready with this matter?
Lord, it appears.
বলছি স্যার এটা রিলিজের জন্য আমি চেয়েছিলাম রিলিজের জন্য রাখা রয়েছে স্যার আগে আমি অনেকবার মেনশন করেছি অ্যাকচুয়ালি আমি লোয়ার কোর্ট থেকে একটা পারপেচুয়াল প্রহিবিটরি ইনজাংশনের ডিগ্রি পেয়েছি তো সেই ডিগ্রিটা ডেলিভারেটলি ভায়োলেট হচ্ছে সেটাকে মানে আমি ইমপ্লিমেন্ট করার জন্য পুলিশ হেল্প চেয়েছিলাম লোয়ার কোর্টের থেকে তো স্যার সেই পুলিশ হেল্পের অ্যাপ্লিকেশনটা লোয়ার কোর্ট রিফিউজ করেছে
কোথায় অর্ডার
স্যার সিভিল জাজ জুনিয়র ডিভিশন বিধাননগর
কোন অর্ডার অর্ডারের ডেট
হ্যাঁ স্যার ইমপিউট অর্ডারটা স্যার কাইন্ডলি দেখুন স্যার একদম লাস্টে রয়েছে অর্ডার ডেটেড 12/6/2026
Yes, Mr. Ghosh, what do you say to this?
So can you see the degree? Prohibitory degree. It can be done under order 32 rule to order 21 rule 32(5).
Yes.
If it is a mandatory injunction, it can be done. And that is why we with police help. That either Lord personally attaching the property or sending him to jail.
Where is the decree?
So can you see the degree in the yes annexed with the
sir page 32 ordering part decree. লিখে দিচ্ছি
appeal is pending, Lord. I am in possession, admittedly.
না স্যার একদমই না স্যার অ্যাপিলেট কোর্ট ওনাদের স্টে পিটিশন প্লাস ইনজাংশন পিটিশন সব রিজেক্ট করে দিয়েছে এবং অ্যাপিলেট কোর্ট এটাও বলে দিয়েছে যে যদি ওনারা পার্মানেন্ট ইনজাংশন ভায়োলেট করেন তাহলে লার্নেড এক্সিকিউটিং কোর্টের ফুল লিবার্টি থাকবে ওই ইয়েটাকে মানে ডিগ্রিটাকে এক্সিকিউট করতে।
সেই অর্ডারটা কোথায় দেখান
স্যার আমি এই অর্ডারটা অ্যাকচুয়ালি করিনি স্যার ওনাদের কাছে মেবি আছে বা স্যার আমি তো আজকে রেডি হয়ে আসি না এটা রিলিজের জন্য রয়েছে স্যার সেই অর্ডার আমার কাছে রয়েছে স্যার আপনি যদি আমাকে পাস ওভার করেন স্যার নিয়ে আসতে পারি
Application is pending, challenging that order. Initially the learned.
স্যার ওটা
হ্যাঁ initially the learned appellate
আমাকে বলতে দিন
initially appellate court rejected our stay application. He said that file an application for injunction so that your possession cannot be interfered during pendency of the appeal. That injunction application was filed. Subsequently, he also rejected the injunction application. Against that, Lord, we have preferred a revisional application. But in 2023, since then, the matter could not be listed. That's why both the matters are pending. You'll also kindly hear. Kindly see the execution.
Where is the other civil revision application?
Other revision application is pending here.
Pending before this court?
Before this court.
Which item?
You know, not before your lordship. The 2023 matter.
2022 matter?
3 sir.
2023, where is the determination?
স্যার এখন যতদূর জানি ওই জাস্টিস শর্মার কাছে রয়েছে
Is appearing in the list?
না স্যার
No, yet to be taken up. Some are now appearing before Justice Sharma, other matters are not appearing.
আর স্যার ওখানে কোনো স্টে অর্ডার ওনারা পাননি ওইখানে কোনো হিয়ারিং ও হয়নি
Have the number of that civil revision application?
Yes. 2937 of 2023.
2937?
2937 of 2023.
That is the civil revision application against rejection of your stay application in the title appeal.
Injunction appeal. In appeal.
In appeal.
That's why I'm not revision.
Yes. So in the title appeal, so you have preferred an appeal against this decree.
Yes.
So there you have paid for injunction.
Yes. Initially stay, it was rejected by saying that you make an application. That court below.
Yes.
But only injunction application was filed. That has also been rejected on the
against that civil revision application is pending, and he is challenging the.
He filed an execution case. the execution case was rejected by the learned executing court, and it was allowed. No, we prefer revisional appeal and said that it is not executable. Justice Sarkar put that it is under Order 21 Rule 32 only by bringing the agitator to jail or by attaching his property, it can be executed.
স্যার এই একদম স্যার একটা ভুল স্যার এই
32 sub rule 5 saying that with police I should be
স্যার এই ব্যাপার উনি যেটা বলছেন অর্ডার 21 রুল 32 তে খালি সিভিল ইমপ্রিজনমেন্ট আর প্রপার্টি অ্যাটাচমেন্ট হতে পারে স্যার এই বেসিসে আমি একটা সুপ্রিম কোর্টের রিপোর্টেড জাজমেন্ট দিতে পারি স্যার অলরেডি আমি অ্যানেক্স করেছি স্যার কাইন্ডলি যদি আপনি পেজ 51টা দেখেন সুপ্রিম কোর্টের রিপোর্টেড জাজমেন্ট মাল্টিপল জায়গাতে স্যার এটা রিপোর্টেড হয়েছে রিপোর্টেড ভার্সনটা তো স্যার সুপ্রিম কোর্টের রিপোর্টেড জাজমেন্টটা যদি
আসুন আহ Next.
Nothing, my lord, I appear for the petition. Lord, order number 60 dated 9th of January 2026 is the subject matter of challenge. My lord, what happens is that, my lord, this is a suit for specific performance of contract. My lord, the defendant number 2 and 3, my lord, are the subsequent purchasers, my lord, who have purchased the property, my lord, during pendency of this suit. My lord,
What is the impugned order?
My lord, the impugned order is that, my lord, I filed an application for injunction. My lord, on the same date, my lord, the learned court below, my lord, fixes the application for injunction on 20th of April 2026. My lord, on 20th of April 2026, the defendant number 2 and 3 filed an application for order 7 rule 11, and my injunction application, my lord, has kept in abeyance.
What happened to the order 7 rule 11?
My lord, the order 7 rule 11, my lord, is still pending for hearing. My lord, on 15th of September 2026, it is again fixed for hearing. My lord, already, my lord, during pendency of the suit, my lord, the defendant number 2 and 3, my lord, have purchased the property. My lord, if again, my lord, something happens, my lord, another amendment, my lord, another application for improvement, my lord, would have to be taken. My lord, my respectful submission would be that, my lord, the order 7 rule 11 and injunction application would be taken up together.
Where is order 22 rule 9?
My lord, order 22 rule 9, my lord, setting aside for abatement of defendant number 1 is concerned.
So unless that
my lord,
is
I am
not
not praying for defendant number 1, only for defendant number 2 and 3.
a suit, unless this
Not only for defendant number 2 and 3. My lord would kindly take, my lord, page 30, my lord, my prayer for injunction.
the learned advocate appearing for the petitioner submits
Item number 14 by 9 for the petitioner, my lord. In this case, the petitioner has filed an application under section 8 and 9 of the preemption filed on 14/1/2020, my lord. In the petition, it was stated 2021, 2020, my lord, and deposit 1 lakh rupees. My lord, thereafter, my lord, date was fixed to pay the remaining amount on 23rd 3/2020, my lord. At that time, the COVID period has started, my lord, and thereafter, my lord, and the smooth functioning of the court was not there, my lord. So on 5/1/2021, the petitioner made a prayer before the landed court below that to make the deposit immediately. On 27/1/2021, he had made the deposit, my lord. Enter amount.
27/1/2021
21.
deposit made.
Yes.
When the transfer took place.
My lord, transfer took place long
This is
time.
a preemption on what
Yes.
ground?
My lord, the
Preemption on what ground? Co-shareship, vicinage, Borgadar, what ground?
my lord, it's written in para 3, my lord. The opposite party was adjoining landowner, my lord. And
Vicinage.
yes,
All
my
right.
lord.
So, what is the date of transfer?
My lord, date of transfer was made on 27/9/2019, my lord, by deed of convenience. 9/2019.
19.
Yes, my lord.
When did you file the preemption application?
Initially, it was filed in 2019, my lord. Thereafter, it was rescheduled on because he had deposited the money on 1 lakh on 2020. So it has been renumbered as Miss Appeal number 1 of 2020. It was
Miss
filed.
Appeal?
Yes, man.
Miss Case?
Miss Case, my lord. 1 of 2020. It was
filed on 2022.
No, no, it is a mistake, my lord.
It should be 2020.
2020, my lord. 2020.
So you filed the preemption application with a deficit code, with a deficit amount.
Installment 1 lakh rupees I had paid, and but there is a judgment also, my lord, in checking paid in installments, my lord, and the court has allowed it.
Where is the judgment to pay? You can pay in installments after the period of limitation.
My lord, there is. But this is the learned appellate court has dismissed the appeal on the ground based on the decision of the Barasat Eye Hospital case, my lord. But in this case, initially the payment of 1 lakh was allowed by the London trial court, and time has been granted to make the payment in installments due, and the period has fallen within the COVID period. So the remaining amount could not be paid. And thereafter, my lord, the date is fixed by London trial court. Before that date, the entire amount has been paid. Because there is no bar, my lord, as per West Bengal Land Forms Act, my lord, that.
Sir, after Barasat Eye Hospital, Abdul Motil Molli, where is the scope to say so?
But this is the judgment of this honorable court also, my lord, because initially, I can appreciate, my lord, initially it was given the chance by the under trial court to make the payment after 3 months.
Sir, what do you know what happened in Barasat Eye Hospital?
Yes, my lord, this is the judgment where
Barasat Eye Hospital, the preemptor succeeded.
Yes, my lord, but
in that matter also, time was not extended to deposit. I appeared in that matter before this High Court.
But
so I know the facts.
But my lord, if your lordship, this judgment, my lord, bypasses honorable High Court. My lord.
Now it's clear. Now it's clear preemption is a weak right. 8 and 9 has to be construed strictly, cannot be done. It's barred by limitation. Ex parte barred by limitation.
But our, my lord, that is, as your lordship, following your lordship, my lord. But as because, my lord, there is a, first of all, there is a chance given by the under court below to make the payment, and
could not have been given a chance. Sir, limitation, if a suit is barred by limitation, can it be chance be given to file?
But this judgment by this honorable court, our court, my lord, states that this can be done because even if the time has been expired, my lord, they're making payment.
Cannot be done. Supreme Court is against Supreme Court.
My lord. This is the judgment because.
Appellate court has referred to those.
Yes, ma'am, that has been referred, my lord. But I have also, this judgment has referred, these judgments also, and ultimately come to the conclusion that that can be allowed. My lord, the judgment that has come to your lordship, my lord. Citing all the decisions and even those Barasat Eye Hospital decisions, my lord. Well, this judgment is there, my lord, where it ultimately comes the conclusion that can be allowed, my lord. The 2021, my lord. Well, it will be hard, my lord, the next date of hearing, my lord. Uh,
Have you brought the decision of Barasat Eye Hospital?
no, my not today, not just now, my lord. Then if you also kindly fix another date, my lord. Yes, my lord.
So, because please bring that, making it not today. Yes. Coming after
If you-
5 days.
On Tuesday, my lord. On Tuesday, my lord. On
Not today.
Tuesday.
I am for the petitioner, my lord. By the last order, Lordship had directed me to serve upon the opposite parties. This is the affidavit of service, all have.
Then, Mr. Manager, it's difficult. I asked your junior that then it cannot be taken up out of turn.
But I understand.
Because you may have served, the advocate may be watching these proceedings.
But I understand that the only aspect is, Malad, the matter is fixed on 18th. Tomorrow.
For what?
Malad, for the argument, last chance argument, and this will be disposed of.
In which court?
Malad, Alipur court.
Who is appearing for the?
But we have served him. He has been
Who
duly
is the
served.
learned advocate who is appearing?
Mr. Nizamuddin Gharami, he has been duly served. That's.
Can you do you have the phone number or
Oh, my
anything?
lord, I do not have the phone number. I tried to get it. I could not. But others have come back, refused, and addressee left. 2 are refused, and 1 to 3 are addressee left.
This matter was mentioned.
The petitioner, man.
Which item?
Item number 15.
15. Yes.
নয়না দোষী।
Yes. এটা কি 15 দিলেন ফাইল? Yes, yes.
My lord, property belongs to one Radha Madhav Banerjee. During his lifetime, he prepared a will to his grandsons and executives was engaged to his daughter. My lord, petitioner is the tenant of Radha Madhav Banerjee. My lord, Radha Madhav Banerjee died in the year 2011. After the death of Radha Madhav,
Give me a minute. Please give me.
yes, yes, my lord, after the death of Radha Madhav Banerjee, his daughter was collected the rent. My lord, thereafter, my lord, in the year 2015, he filed a eviction suit against the tenant. And on 15th of
Who is the tenant?
present petition. My lord, on 27th of February 2015, ex parte degree was passed. My lord, thereafter, my lord, on 29th of June 2015, probate was granted. Executives filed this execution in the year 2021. After obtaining probate, and executives can file this execution case after 6 years, lapse of 6 years. Thereafter, my lord, Order 21, Rule 16 was filed by the one of the probate holder. Out of two probate holder, one of the probate holder filed this application. And your petitioner filed an objection before the concerned court. Thereafter, my lord, this order was passed. Challenging the said order, I came up before your lordship.
Please show me the decree.
Page
Huh?
12. Page 12.
My lord, page 12.
12.
Operative 19. Operative part, page 19.
Operative part, my lord, page 19.
When the probate was obtained?
My lord,
29 June
29 June
2015.
29 June of
2015 on the same year. মানে February, month of February, execution case was
No.
eviction.
The decree was passed on 27th of February 2015.
Yes. মানে on 29th of June 2015, probate was granted.
Yes. So the decree was passed prior to that.
Prior to that.
Yes.
And thereafter,
So that
my lord,
decree was put into execution.
execution, that
Execution case was filed when?
2021
Yes.
by the executrix,
Yes.
not by the probate holder.
Yes.
Well, thereafter, my lord, in the year 2020-22, my lord, one of the probate holder filed an application under rule order 21, rule 16.
Yes.
That has been allowed. Challenging this order, my lord, I came up before you.
Yes. What is the difficulty? He cannot be added. Why?
No,
Why
my
he
lord,
cannot be added?
my question, submission before your lordship. My lord,
So what is the law during the pendency of a probate proceedings? Who can represent the estate?
My lord, decree was granted in the year 2001, 2015.
Prior to the grant of probate. So at that point of time, the executors were representing the estate. So where is the difficulty? That decree was there. Where is the difficulty? Now the beneficiaries has come in, because in the meantime, after the grant of probate, the property has
my lord,
devolved upon the
that execution was filed after lapse of 6 years.
What is the period of limitation for filing an execution case of a degree of eviction? What is the period of limitation?
Well, at that when
I'm asking you, what is the period of limitation?
My lord,
You are the beneficiary of the delay. It's only you are the beneficiary of the delay. Then now the beneficiary has come. So property devolved by virtue of the probate. Where is the difficulty?
but my lord, one of the probate holder accepting the rate.
He has adjusted.
Your lordship kindly consider this aspect on also.
Very good case for dismissal of the execution. Please fight it out. Ashun, this application under Article
collected rent from the petition.
He also not interested to evict. Joint property কি করে evict?
Yes, next.
Your Lordship kindly stated this line.
That's neither here nor there. If he is in your support, take his help. Yes, who is appearing? Yes, what is
Item
this?
number 16, my lord. I am for the petitioner, my lord.
Yes.
My lord, I have come up. The impugned order is at the very end, my lord, the small 2 pages, my lord.
Yes.
My lord, this is a matrimonial proceeding where the wife, I am the husband, my lord, where the wife has filed a matrimonial proceeding seeking annulment of the marriage. The marriage was registered under the Special Marriage Act.
Wife has filed.
The wife has filed for annulment.
Yes.
Under section
What is
25.
what is the application which has been rejected?
The application is this, my lord. My lord, in a situation where a person is seeking a voidable marriage, my lord, it has to be on several grounds. One of the ground is non-consummation of marriage. Me as a husband, I admit that there is no consummation ever. And this application is stating that, yes, allow the decree. Give annulment. There is no consummation. That has been rejected. Wife prays for, Lordship will kindly seize this, my lord. The plaint is at page number 25 and the prayer is at page number 29. That is the mat prayer, my lord. The main suit prayer, my lord, filed by the wife. Decree of nullity such and such. My written statement, it starts from page number 31. Kindly takes page number 39, where I've specifically made a case in the written statement, in paragraph 9 at page number 39.
So please show me the plaint and the.
Yes, my lord. I'll take lordship to the plaint. Plaint is, it starts from 25, my lord. The plaint starts from page number.
According to you, a decree ought to have been passed on admission.
That's right. According to me, absolutely on admission. My lord, may I just show the plaint, the relevant portions of the plaint where she is saying.
Believe that allegation, please show me
Yes,
which
my lord.
paragraph.
In the plaint, my lord, your lordship would kindly take page number 27 once.
Live streaming number.
Yes, my lord.
This application under Article 227 of the Constitution of India is that statement.
2019 suit my.
Yes, caller next matter.
Item number 781.
My application. Short.
Short.
Very short.
Volume does not say so.
No, not required. Look, Order 6, Rule 17 allowed. Your Lordship will just have a look at the order. That's my first ground of attack. It's absolutely unreasoned. Please just have a look at the order once. No?
Order 6, Rule 17 of what?
Of the plaint. I am the defendant in the suit. 2016 direction for issues, framing of issues. Admitted case when he drawing up the he's drafting the examination in chief.
But Mr. Banerjee, what is the amendment application? Please show
Yes.
me that.
Before that, with your Lordship, just have a look at the order once, the impugned order once.
I've seen the order.
Now I know why your Lordship seeks the. The amendment application your Lordship will find at I'm sorry, my Lord, page 290. I'll tell you, Lordship, what I'm unhappy with and why I'm saying that the order is unreasoned, because
what is the suit for?
The suit is for declaration that the plaintiff is the owner. They rely on a particular declaration
that the plaintiff is the owner.
That the plaintiff is the owner.
Yes.
In that suit, in particular paragraph, Lordship needn't be troubled with the papers right now. In that paragraph, he refers to a particular photocopy of a deed by which the plaintiff claims to have acquired title. He mentions about my deed, no other pleadings at all. In that
why your deed?
He mentions about my deed because I have actually purchased the property. His deed is a fictitious deed. It's a false deed. At the interim stage,
denies your title.
In a very
says that he has acquired title by virtue of some deed.
Of a deed that is prior to mine.
Yes. So by virtue of a deed.
Of some deed.
Yes.
Through the interim application, all that order passed, refused, comes before this honorable court. This honorable court holds that the deed is a fictitious, it's a false deed. Because the stamp is not there, it gives a detailed reasoning. I'll show that order. That deed is referred to in the plaint, copy not produced. That deed is annexed as a certified copy of that. Xerox copy is annexed with the injunction application. In the written statement, we say it's a fictitious deed. Now, two amendments are being made. One is my deeds for the first time are being called false and not binding on the plaintiffs. This pleading is not there. Suit is of 2014. So that's a right that's accrued to me. He's not assailed my deed. He does it for the first time now in 2026. Second, that deed of which he craves leave to and he asserts there is a photocopy, which I say is fraudulent. High Court also holds is fraudulent. Now the amendment that he is now trying to bring in is that while coming in a tuk-tuk, his lawyer lost that deed in 2023. And therefore the deed is now lost.
His deed?
His deed is now lost. But your Lordship now understand, which is why I was saying that reasoning is important in the impugned order. But before that, at this stage, I don't think I need to trouble you. That paragraph I'll show. 2014 suit. 2023, apparently his lawyer was coming by way of a tuk-tuk and lost it. I may be getting the vehicle wrong. I'll show that paragraph. Please have a look at page 293.
issues framed.
Show me the plain ones.
Yes, yes.
Page
47. It starts at 44. But what your lordship is looking at is at page 47, paragraph 3. I think this is what your lordship is looking for. Paragraph 3 is and if your lordship keeps 293 side by side of 47, this is the amendment now he's trying to bring in. So now the story changes. Why I say changing the nature of the suit, maybe not character.
No, he wants to add some prayers also, reliefs also.
No. No, the substratum is taken away. The implication of this paragraph, your lordship understands, Lord, why he's bringing in the paragraph 3 by way of this amendment. His requirement of evidence, everything changes, especially after the dishonorable court holds.
Mr. Banerjee.
Short only.
Yes.
Item number 19. I am the petitioner, your lordship. I am the respondent in an appeal proceeding asking for expeditious disposal of a
Respondent in an appeal.
Yes.
What is the suit for?
Your lordship, this is a proceeding before the DRT. Your lordship, the background is the appeal is filed in 2022. I am a successful.
You can go before the DRAT also. There is a provision.
Your lordship, only expeditious. Kindly see the.
You can apply there for a
Lordship,
direction for.
Your lordship, let me place the case. Your lordship, kindly see 2022 appeal.
There is no provision to go before the appellate tribunal for a direction.
227 powers are also there, your lordship. Kindly see.
No, if there is an alternative forum which also has more or less similar provisions, why 227 will be?
The situation is such that your lordship kindly sees once 2022 appeal 35 dates in that.
The appellate tribunal cannot pass an order for expeditious hearing.
I am before your lordship.
There is a provision.
There is a problem. But your lordship, the situation is so grave, your lordship, that some indulgence is required, your lordship. It is just that the next date is fixed on 11th of August. 4th of August 2025, the appeal court.
Where is that order?
Your lordship, 4th of August. Your lordship, the order starts from 207.
No, where is the last order? Where?
Your lordship, last order was actually the last date was subsequent to filing of this civil revision, your lordship. Then I have to bring it on supplementary affidavit.
This
the matter was not taken up, your lordship.
This application under Article
Lord, I beg to appear for the petition in this matter. Lord, the issue is with respect to Lord affirmation by the State Commission of an order award passed by the District Commission. In a situation where Lord, the company is struck off and the responsible director is also dead. At that situation, Lord, the proceedings have been initiated, award has been passed, and thereafter, Lord, appeal has been also carried out. Lord, entire proceeding is flawed. May I take your Lordship first, Lord, to Lord, the kindly comes to page 15.
1-5.
1-5.
What is the order which you are challenging?
No, the order is of the State Forum affirming an order whereby, Lord, affirming an award of the District Commission, whereby, Lord, I have been directed, rather, Lord, the company, including me, have been directed to pay the compensation. What has happened, Lord, in 1991, Lord, this property was owned by this company.
Did you take this point that the company is no longer in existence?
So those were placed before the forum.
Mr. Karmakar, if you have, please show me that you have raised. It's difficult. You are saying yes, those who are.
Lord, yes, I'll take your Lordship, Lord, parata.
If that is not there, please go there and take this, that these points were.
I'll just indicate one point and thereafter take your Lordship to the award. So what had happened is 1991, this property was owned by the company. The company promoted and developed it and sold one flat. Agreement for sale with this particular predecessor of this Lord complainant. Lord, since 1991, nobody contacted with the company. 2015, the company issues a notice to the complainant. He is not there. The company publishes a newspaper. In the paper that we are going to sell it off. Please contact us, get it registered, else we'll resign your contract. Lord, immediately thereafter, the company enters into a contract with someone else, the flat is sold out. Now after, this was in 2016, 2020, Lord, this application is filed with a condonation of delay of 22 days. The complaint is entertained, and by that time, the company is also struck off. The person, Lord, who was the managing director at that point of time is also not there. We too are where? Lord, directors in the company, today the company is not there. So, Lord, we also do not have any privity of contract with them. So, the question of, Lord, consumer dispute, consumer forum, Lord, does not.
Why are you challenging this then? Let the order, let them execute that.
No,
why have you?
The problem is we were parties.
Karmakar, if you say that you are nobody, you were there, company is not there.
But the award has been passed against us.
Directors are not there.
Award has been passed against us individually. The award has been passed against us individually. I'll take your Lordship, Lord. Kindly, Lord, takes page 37.
Yes.
This is the paragraph 1 of my, Lord, appeal before the State Forum.
Please show me the District Forum order.
Yes. Lord, that's the first, Lord, impugned order.
Which page?
Lord, page, your Lordship, it's a certified copy.
Certified copy?
Certified copy, Lord.
Both forums order certified copy you have annexed?
Yes, yes.
Exceptional case.
That has to be done. You have learned that from your Lordship.
Exception now. It's an exceptional case now.
That's what we have learned, Lord.
You have learned the exceptions, not the rule. Yes. This is the
no, this is the case made out.
Opposite parties.
1 to 4 were the opposite parties. 1 is the company, 2 is the managing director or our father at that point of time, and 3,
no,
4.
The award was passed against all.
All.
Yes.
That's exactly what I'm on. Lord, I have no privity. That's on merit. That's on one aspect. That's on merit. Today I am on, Lord, this. How could this proceeding be continued?
But this was ex parte.
This was, Lord, we had contested. I should.
In what capacity you contested?
Lord, I contested as individual. Kindly seize, Lord.
Did you raise this point that you do not have any privity of contract? Please show me that.
Not in the written version we had indicated.
Not in the written version at the time of argument.
No, that's the written version, Lord. That's the Lord, the argument, Lord.
Mr. Kormakar, you may have taken many points in
I
your.
know, Lord. But the problem is, Lord, if
Now,
the tribunal
if you have taken that point, district commission, district forum has not considered that. In the appeal, did you take that
kindly
point?
comes to page 37. The first point. Kindly
37.
comes to page 37. My first paragraph is on that.
37.
Yes. The subject complaint, my lord has kindly got it, Lord.
Yes.
The subject complaint was filed by the respondent before such and such against one Mondira Construction and one Ramprasad Bhadra's directors of such and such, were directors, but during pendency of the complaint, died intestate suffering. So, my lord, he died, expired. The appeal number
That
one
you
had
raised
also
this. No,
defunct.
not that. You raised this point and the district commission did not take into consideration
Lord,
that there is no PVT of contract, this and that,
perhaps,
what you are
Lord,
now saying.
No, that's a point of law, my lord. That's perhaps not, not in so many
Mr.
words.
Kormakar, you have not taken that point.
But
Before
this
either of
is
the
taken that the
maybe in writing,
continued.
not in maybe in writing, not at the time of final hearing.
Limitation জিজ্ঞেস করছি। Lord, I'll just indicate to your lordship.
Please show me that you have raised this specific point.
Lord, kindly comes to page 43.
It is very easy to say that everything is dissolved now. Where the complainant will go now?
The complainant has other remedies. Not today, not only because I can afford.
But what remedies? What remedies?
The company has to be restored. Thereafter, the claim is against the company. No, the directors cannot be held liable. No, this is a company matter, my lord.
Yes.
The directors cannot be held liable. And my lord, at that point of
Please show me that you have raised those points.
Yes, my lord.
That you are the you are not responsible. The company is responsible. Please show me those points you have raised.
Lord, kindly comes, my lord, to page 43.
No. In the order, from the order, please show me.
From the order, my lord, nothing is recorded.
Mr. Kalmakar, if you say that, you have to go back to that. That I have argued this, it was not recorded.
But unfortunately, it's been disposed of. Nobody will
Orton is
entertain.
coming. Yes.
Lord, nobody will entertain me.
That's the law, Mr.
Kindly
Kalmakar.
sees, my lord, how it is proceeded with that, Lord, the state commission.
Nowadays, this is coming up.
Lord, the state commission orders.
In
Lord, I
almost all
find
matters,
more
it
of
is
a-
coming up. You will not raise that point.
Lord,
You appeared before the state commission. Who are the advocates who appeared before the state commission?
That, Lord, I
Ask them to appear before this court.
Lord, I find one SS.
You cannot say, Mr. Kalmakar, that you have raised that point. You are not the person.
I was not there.
Have you stated on affidavit? Have you stated on affidavit that these points were raised in the course
Lord,
of?
I am stating, I am showing page 37. That
Page
is on the
37
affidavit.
will not do. From the revision application, specifically, the learned advocate who argued, has he taken this responsibility that he has argued this point, not recorded? That will
May I
not.
bring him in that case, my lord? Lord, this point was taken that the company is defunct and this person has died. These 2 points were taken.
Show me that you have taken that indeed.
Number 1 is that.
In the order, Mr. Kormakar,
Order, your
you have
lordship
written,
finds
you have annexed many documents, Mr. Kormakar. In this
forum
petition,
order.
it is very difficult to go
The
through
state
each and every page and
the
all
state
points.
forum order is more of like Milord Gitanjali rather than Milord some order. Milord kindly sees Milord the state forum Milord finding. Kindly sees the language. Milord he diverts
Sir,
from
Kormakar,
everything
it's,
but from doing this.
one advocate will appear before one forum. Another advocate will come and say, yes, my counterpart has raised this
May I
point, recorded by the.
May I indicate this limitation point? If I do not take, then also it's court's responsibility not to find out whether it is within the limitation or not.
According to you, the complaint was beyond limitation.
First. Second, the complainant.
You have said that it was condoned.
Section 22 days. Lord, I'm not on that at this point of time. Lord, what I'm
So,
on is
there's a power to condone. It was condoned.
22 days.
Yes.
But the calculation itself was wrong. Because I published notice, the sale deed was registered back in 2016. Complaint is being filed in 2020.
Cause of action is a bundle of facts. When the cause of action.
The cause of action, they say that the cause of action is from the notice when they gave us to comply. By that time, Lord, 3 years have already passed while the property was sold out.
How much amount has been directed to be paid?
Not 2.5 lakhs. That was not the problem. 10% interest from 1991, where I was not at fault. Not your property. You will not come. You will not contact. I'll send notice. Then also you don't come. I make paper publication. You don't appear. I sell it. And thereafter you not raise from the slumber after 5 years and not come swinging hands before the forum saying that I have my claim because I am a consumer and he's a promoter. But the only consideration is that I am a promoter. That's why I will be crucified. That's the only logic.
No, you are not a promoter. Company has been dissolved.
Yes. The logic is that I am
an ordinary person now.
Not the logic is I am a promoter. That's why I should be crucified without considering that the promoter or I say not even
All
the company
projects
was
failed,
not a
Mr.
promoter.
Kormakar. All projects failed.
But I say I was not a promoter.
Why your company was dissolved? You don't have any other work.
Not the perhaps the nothing.
So many directors.
Yes, I have annexed.
That is what I am saying. So many directors.
No, I have annexed.
So now the business is
kindly comes to
lucrative business,
142.
mister. When did you stop your company? Dissolve your company?
Kindly comes to 142.
What period? What date?
I have annexed it. Kindly comes to 142.
Please tell me the date.
2018.
2018, it was a lucrative business at that point of time.
But I could not do. And there is no claim against me from any other corner.
You have not done anything. That is why there is no.
Exactly.
That is why there is no complaint. No, you have not done any work.
But the question is, Lord,
If you
how
do
can
some
a
work,
claim,
there will be some mistake.
how can a claim be resurrected against a dead man or dead company? Lord, if I have a claim against a dead company, there are other procedures. Consumer protection cannot be invoked. Lord, kindly cease. Kindly not comes to 142 once. Kindly comes to 142.
Go back to the state commission, file an application stating that I have argued this. Those points were not taken note of.
Lord,
Otherwise, Mr. Kormakar,
Lord, I understand. Lord, I do not have any difficulty in going back. But the problem is, I won't be entertained there saying, Lord, kindly seize the language, the manner in which this has been disposed of. Lord, I should not show your name, the Lord, the way he has dealt with and written. Lord, I just find this more of Lord, other than an order, anything else.
State commission.
Kindly seize the language. I was thinking, I was reading Rabindranath.
You don't want to read?
Kindly see. I'll place it. Decision. Paragraph
Mr. Kormakar, go there and say that I have argued this. It
So
was
the
not
problem is I
recorded.
will be entertained. Your Lordship kindly reads.
That's the process. That's the
So your Lordship remands the matter.
Demand's been setting aside, Mr. That's
Lord, this aspect had to be considered. This was not considered.
provided you have raised that.
This is
That's
a
the
point
only
of-
issue.
This is a point of law. This is a point of law.
What is the
Proceeding
point of
against
law?
a dead company. This is a point of law.
Raise that. I give you that liberty. Go before that review, Mr. Kormakar. That's better because it's difficult now.
Lord,
You have not raised your counterpart.
perhaps
Now
the
you are,
State Commission
the
does
client
not have.
has come to Mr. Rahul Kormakar. He is saying, yes, these are very good points. This can be raised.
Review perhaps not with deepest respect, not the review perhaps not the State Commission does not have.
Why?
Review not only the National Commission has, perhaps not. If I'm not
Please check up. 86 on 2019.
2019.
Please check up.
Not review the power State Commissioner review portal. আছে কি না দেখেন ন্যাশনাল কমিশনের আছে So then again,
Not there. After amendment, it's there.
The only
86, it was not there.
the only difficulty will be Lord, review. Your Lordship knows, Lord, things will be very limited.
Yes, because that's the limited issue, Mr. Kormakar. Whether you have raised this issue or not, that's the primary fact.
The
If you have not raised
drawn up against the
superior
dead-
forum,
Not from the records I am showing your Lordship, I had raised. From the records I am showing.
it's difficult, Mr. Kormakar. 5 volumes, 6 volumes, 7 volumes of civil division application.
Lord,
All the pages, it's
give
difficult.
me 1 minute time.
It's difficult. You may take 10 points. You may
I might not argue.
think fit, yes.
But I understand what is calling from your lordship.
Please go there. I give you that liberty. Take because the advocate who has moved, he has also to take some responsibility. That he has raised this point.
The point was raised. Documents are there on record. Not point was raised.
If you have
The-
not
the forum
raised
proceeds.
means in the application it was there, Mr. Kormukar.
Lord,
but
if
you
the
have not
Lord,
placed
if
that.
the order is directed Lord in a different direction, Lord, what can a lawyer do? Lord, the order is not passed in open court, Lord, just like high courts, Lord. Your lordship knows much better than me.
Complainant was represented by an advocate of this court.
Huh.
So we can also support you if you have said yes, you have argued.
Yeah, but the problem is, Lord, if the commission does not write, then Lord, the scope of the commission has taken a view. The view is directed to
Taken,
the particular.
Mr. Kormukar, taken a view on certain facts. You are saying that I have argued this. Whether you have argued or not, that's on facts.
That's why, Lord, on facts, these are on record. I'm showing your lordship. Lord, what my prayer is before your lordship, Lord, remand this matter back, Lord, so that on the ground, that whether, Lord, the complaint could have been entertained against, Lord, a dead company. Let the commission decide on that.
Petitioner is directed to serve a copy of this application upon the execution will not be done.
They will execute the commission, Lord, your lordship. Lord, these days, Lord, the only target.
How much amount? You deposit the amount, money degree.
Already 5 lakh rupees Lord, deposited with this forum.
What is the decretal amount?
Decretal amount is not more than 20 lakhs.
Please deposit that. Money degree, no stay without depositing.
Lord, 5 lakhs I have deposited.
Maybe.
Lord, I am not.
No, you deposit, you secure that. You are not paying to them. You are not paying to them. That's the law, Mr. Kormukar.
I understand, but other than that, also,
You secure, I will stay that. You secure the balance, deposit it. I will stay that.
Lord, directs me to pay some amount, Lord, not the entirety. Lord, I am not a.
This deposit 20 lakhs is not much.
20 lakhs is a big.
No.
The property was sold at 17 lakhs. He did not do anything. Lord, my predecessors did, and thereafter the company also gone. From the district commission's order.
Yes.
Lord, last page.
Yes.
Disposed of directing OPs to return 2.48 lakhs with 10% per annum from 1992.
And plus 5.
And thereafter 5 lakhs and 50,000. So 5 lakhs it's already deposited with the forum. So permits me to deposit with the court 5 lakhs.
What is the amount which is coming now?
So the quantum,
20 lakhs.
Quantum somewhere around 18 or 20 lakhs.
20 lakhs.
Permits
So 5 you have deposited.
I have already 5 deposited.
So deposit 10. There shall be an order of stay
Item 42, my lord, is for protection of an 8-year-old girl child. My lord, the division bench has also requested your lordship, my lord, to consider the matter. There's a contempt, my lord, pending on my head. My lord, I adopted the child when the child was 1 year old.
Today it's difficult.
Today she's 8 years old, my lord. The biological
it's
mother has
difficult.
popped up after 7 years and obtained an order, my lord, to, my lord.
I can keep it on 1st of August.
Can your lordship, my lord, indicate that the matter will be on the 1st of August with some certainty, my lord? Item number 42, my lord.
Item 42. This matter, you are for the petitioner.
I'm for the petitioner, my lord. My lord, I must also fairly say there's a caveat. My lord, we had a word with the other side. They said that right now they're in difficulty. They can come after
2 p.m.
After lunch, they can come.
Please bring him at 2 p.m.
Great.
Your Lordship, one indulgence. Item number 63, Mr. Nag was supposed to reply. Your Lordship did not fix a time yesterday. Mr.
Difficult to take up today. Let me see how far I can proceed.
Great.
It's difficult, Mr. Nag.
Well, not possible because I was just supposed to give reply.
That I follow, but
All
the
my
orders,
all other matter fixed.
other matters are there because from Monday I will not be available. That is why these things are.
My lord, my other side, my lord, is there.
Yes,
For
you are
item
appealing.
number 42.
Yes, your lord.
Your
Yes.
your lordship.
My lord, if you want, I can fix it on 1st of August or let it remain. If there is urgency, you can mention before the bench. There will be a bench. Urgent matters, you can.
My lord, that, my lord, we are not sure, my lord, whether, my lord, because, my lord, the request,
It
my
will
lord,
be there, what you will not be. Otherwise, it will remain. In any case, if it is not taken up on first, it will be there. So, if before that, if you can, it will be.
No, I'm not interested. I have some difficulty, personal difficulty.
my lord, can it be on another day of my friend's, my lord, convenience? Because he's saying he's in difficulty on the first.
If it is not on the first, it will stand over till the next day. But if
Trouble
you
is,
can get a chance before that, you can also move that.
my lord, the contempt is scheduled on the 21st of July. Before the
Yes.
division bench.
Yes.
My lord, they
So
want.
that is why you can get a chance, you can mention before the bench. Citing the urgency, if that is moved, you can also do that. Let it remain, otherwise on first or anything.
First. First, my lord, I'm okay with first. My friend is saying he's in difficulty.
Yes.
Very
yes,
good.
Mr. Vadajaji. It might be difficult.
Kindly will not any time today. Any time today.
Today it will be difficult, Mr. Vadajaji, because
He is just in his reply.
he will be in his reply. My officers are to do, those orders are there.
No, I'll be losing 2 weeks. Kindly also visualize our predicament.
It will appear on first. It will remain on first. It will remain on first. So
Kindly fix that time on first.
1st of August you come, I will take it up. No problem. It will be available on first.
No, it is not the first is what's the Shonibar?
Day, working Saturday. Yes, Mr. Vardhan, what are you saying?
Can it be on 4th? No. First.
Yes, call the list. Yes.
For expectations is for this is the last 3 orders which were not with the
Yes, expeditious disposal of what?
of my I'm the plaintiff suit for partition of
You
2008.
want the disposal of the suit?
There's an application for appointment of if a receiver is pending and the suit as well 2008 suit.
What is the next date fixed?
Next date is on 22nd of September. My lord, the certified copy I just handed over. My lord will find.
For order 40.
Order 40 rule. My lord, kindly seize the last 3 orders, all adjourned on the prayer of the defendant.
All adjourned on the prayer of the
defendant. Not even resolution of the bar, prayer of the defendant.
This application under Article Not today. Next.
Same parties, different suit, pending since 2008. Partition suit, PW1 has been done, PW2 has been done. An application for recalling the PW2, who is the commissioner, witness commissioner, that is pending. Next date is on 16th of September.
For recalling of
PW2, who was the commissioner, witness commissioner. PW1 was done on commission, and the
by which order? Because here
last order, my lord, kindly says
2nd of April 2026, 9th of July for
9th of
proper
July
step.
after, yes, my lord, respect of petition dated 6th of 8. My lord, kindly see the previous order to that, my lord.
Yes, in respect of petition dated 6th of August
Yes,
2024.
Yes, my lord.
Where is that?
That is not with the record, my lord, that is for recalling. My lord, will find that from the order itself. 20th January order, my lord.
6th of hearing of the petition dated 6th of August or 8th of August?
6th.
Because 8th of August, I think. No.
My lord, it is.
Because there is, please see the certified copy of the order dated 14th of September 2025.
But the order itself records it's 6th of August.
But other orders record
8th of August. That application pending, one application is pending for recalling. My lord, kindly records that.
For recall of
PW2, who was the pleader commissioner.
Recall of PW2.
PW2.
This application under
on the division of petition and lawsuit. Suit for declaration, consequences, and permanent and mandatory injunction.
What is the order under challenge?
Local investigation report was accepted. My objection was rejected. That was the challenge. In the commissioner specifically deposed that no fixed point was taken. Without fixed point lawsuit, no lawsuit. Without fixed point.
Where is the scope of rejecting the commissioner's report? Please show me from the provisions.
Without
automatically an evidence in the suit.
Lawsuit.
No. Order 26, Rule 10(2).
Yes.
Where is the provision for rejecting the commissioner's report? It automatically forms part of the report record. It's an evidence in the suit.
Yes.
You only have a right to cross-examine. That you have done.
That was done.
Veracity will be considered.
On the
that is the question of rejecting this.
No, on the basis of my objection, commissioner deposed.
Sir, please see Order 26, Rule 10(2).
Procedure of commissioners. Commissioner, after such local inspection as the deems necessary, and after reducing writing the evidence taken by him, shall return such evidence together the report writing signed by him to the court. Report and deposition to be evidence in the suit. The deposition not taken by commissioner. Commissioner was not taken any deposition. Commissioner on basis my
please read it in whole.
The report of the commissioner and evidence taken by him, but not the evidence without the report, shall be evidence in the suit and shall form the part of the record. But the court, in the permission of the court, may parties to suit examine the commissioner personally, open court, Oh, examination was done, Lordship. Examination.
What is the scope of rejecting? Please see order 26, rule 10(3).
Any person where court for any reason dissatisfied with the proceeding, the commissioner may direct a further inquiry to be made. You think fit. Yes. Where the court is.
Exception under 3. Sir, once it has been filed, it automatically forms part of the record.
The report was accepted provisionally.
It has to be accepted. Law says that. Please see that it is an evidence in the suit, forms part of the record.
But
yes,
Really,
you can raise that points at the time of final hearing, and you have a recourse under order 26 rule 10(3). Please see order 26 rule 10(3).
Yes, where the court is from the regions dissatisfied with the proceeding of the commissioner.
Yes,
it may direct and further such inquiry to be made. He thinks fit. Lordship, already commissioner deposed. Deposition was considered.
You are not appreciating that. You take recourse under order 26 rule 10(3).
I already raised an objection. That was already rejected.
Sir, rejection, when the commissioner's report is filed, you have a right to file a written objection.
Yes.
You have a right to cross-examine.
Yes.
That you have done.
That was done.
Once the commissioner files the report, it automatically forms part of the record. It is an evidence in the suit. Can an evidence be expunged?
No.
So what is that? You are saying that. So it has to be accepted. What is the effect, admissibility, that has to be considered at the time of final hearing?
No, my point, Lordship, kindly, our High Court judgment, Lordship, that was also rejected.
Yes.
Commissioner report also rejected.
Yes.
Lordship, that was reported in 2019 volume 3 ICC.
Yes.
That was also, I am the opposite party, Lordship. Kindly see. That
lost there or you won there?
Lordship?
You have lost there.
At I lost.
You lost. Now you cannot lose.
Kindly see.
You have to win here.
These regarding 2 points, notice as well as fixed point. That was done, considered and rejected the commissioner report and directed to the court to press inquiry.
Order 2009 3 ICC 619.
Lost.
No, this is in. Which paragraph?
Lordship, ordering portion, Lordship, last. 2 things was raised by the petitioner against the acceptance of the commissioner report regarding notice point.
Where is the which paragraph?
That's only one copy, so that.
This is not on the issue of acceptance of the commissioner's report.
Yes,
this is an injunction.
No.
Please show me which paragraph.
Lost. Paragraph number 36. Paragraph number 36.
36.
40 onwards.
40 onwards.
Lost.
Notice was not served. Their notice was not served.
Kindly see 2 points regarding fixed point as well as notice. Initial notice was,
Since notice was not served, it was set aside.
Yes, another point also, Lordship, fixed point.
Sir, if the notice is not served, where is the question of going to the other part?
No. In that case, initial notice was served by commissioner work was done 3 or 4 days. Another day notice was not served. Initial notice was served. To that extent, Lordship, I already submitted several judgment also. Once first time notice was served, second day not necessary. But only just consider that no, every day notice should be served. And another point is a fixed point.
That apart, the petitioner is justifying in arguing that the commissioner on the first date of commission, that is of itself gave notice indicating the commission would start from 10 a.m. Such mention of time could not be a mistake as argued by the opposite party. In view of the corporation having admitted in this cause that he mentioned 10 a.m. as the starting point for July. Thus, a reasonable doubt is cast as to the veracity of the commissioner's finding in the report, as both sides have failed to point such and such. So the notice was under challenge.
Next, Lordship, regarding fixed point, also 3 fixed point was taken only one side.
Cannot be done.
Lordship, another Lordship,
how can it be expunged from the records? It's against the statute.
If they are not restored, the second commissioner's position is there, Lordship.
That is why I'm saying Order 26 Rule 10(3).
Yes, if
first you can take steps under Order 26.
Yes.
Cannot be expunged from the records.
Lordship, first commissioner report must be rejected, then second commissioner
cannot be rejected. Where is the provision?
To that extent, Lordship, I am showing this judgment. First, without first report or rejection of the first report, second commission cannot be done. Also, another judgment, Lordship, AR 1990.
First of all, 227 is not maintainable against acceptance of commissioner's report. There's a Supreme Court judgment on that. Have you brought that? Against acceptance of commissioner's reports, revision is not maintainable because no case is decided. I think there is a judgment of 2000 or 2001. Yes, Mr. Vardhan, do you recollect that?
1990.
Right hand side, its judgment starts, nearing the middle, ends. 2 or 3 paragraphs.
Advertise of books, right hand, left hand.
And in the next page, left hand side, only 1 paragraph. Judgment ends. Ratio is acceptance of commissioner's report. Civil revision does not lie. No case is decided. Because it's only a piece of evidence to be considered along with other evidences on record. Yes, Mr. Das, please come with those.
1990 Odisha Lordship.
Supreme Court, have you brought that?
No.
Please bring the Supreme Court.
And I already point out, showing the judgment without rejecting the first commissioner report, second commission cannot be done. Our High Court also.
Sir, provision, please show me the provision is against you. Provision does not show for expunging the report.
No, if illegality is the commissioner work, specifically Lordship, in the guidebook of the commission work, specifically stating without fixed point, commission cannot be done. Without fixed point, commissioner go and imaginary point.
The Supreme Court judgment is there.
Lordship, I bring those judgments also.
Bring those judgments, and I've considered the Supreme Court judgment in one of my judgments on this. Cannot be done. The entire procedure, what's the effect, everything is considered. I can give you the lead. That's in Ram Janmabhoomi matter. Temple. They are the Honorable Supreme Court, 4 or 5 judges. Judgment is there on this Order 26 ruling.
Also, I bring those judgments.
The petitioner is directed to serve a copy of this application upon the opposite parties by register speed post with acknowledgement due and file an affidavit of service on the next date. List this matter on August 25, 2026 under the heading motion.
Lordship, in the meantime, Lordship, otherwise Lordship should proceed.
What? Let the suit proceed.
Lordship, in the meantime, otherwise should proceed, Lordship.
What is the stage of the suit?
Evidence started, Lordship.
Let the evidence proceed. Nothing will happen. What is the next date fixed?
Last date is 16th.
Let the evidence start, nothing will happen. Yes, next.
May I permit it to
take back this? Yes.
Right, my lord, I have appeared on behalf of the petition. And this is a case, my lord. And the acquisitions of the land was held in the year of 1975.
Yes, what is the order under challenge?
The order under challenge, my lord, award has been given. We preferred an application.
Land acquisition award.
Land acquisition.
1894.
1894. Award has been given. We preferred an application under section 18 of the 18 of the Acts, 1894 Act. Subsequently, the matter, the order of the section 18 of the land acquisition 1894, it was put for the executions. And now the problem is that the execution proceeding is delaying delaying due to the laches on the part of the government authorities, my lord. That is the most difficult. And my lord, one more important thing, my lord, one writ application was preferred by the similar claimant of the same acquisition
Directed to serve a copy of this application upon the opposite parties, as well as upon the learned government pleader, High Court, Calcutta, and file an affidavit service on the next date. This matter in the month list of September 2026 under the heading motion. Yes, next.
My lord, similar matter, my lord, 28.
28.
28, 29.
28, 29, 30.
30, 31 and 32.
31, 32, same order. 28, 29, 30, 31, 32. Parties are same.
The claimants are different, but the parties are same.
Yes. 32. Yes, call the next matter. No, 26 to the
32. 26 plan. 26.
26.
26 টা কি হলো?
26.
25 টা আমাদের ছিল 26
And I am the petitioner. This is for the expeditious disposal of a suit for declaration and injunction. It was instituted on 7 July 2018. Injunction application. I'm one of the defendants. Ad interim order passed at the inception stage. Injunction application still pending. My order 7 rule 11 that also is pending. 2018 till 2026. That is why I'm seeking. The orders are from 116 onwards.
Order 7 rule 11 when it is fixed.
But it's pending from 1st August 2019. And despite.
You are which defendant?
Defendant number 2, my lord.
Summons not served upon defendant numbers 5 and 7.
May have been served, but at least the injunction application, my order 7 rule 11 has to be heard. If it is not maintainable, how can it be?
This application under Article 227 of the Constitution of India is at the instance of the defendant praying for a direction upon the learned Judge Second Bench Civil Court at Calcutta to dispose of title suit number 724 of 2018 expeditiously. First of the learned advocate appearing for the petitioner submits that the application under Order 7 Rule 11 of the Code of Civil Procedure filed by the petitioner is pending. So he submits that when it is fixed for hearing.
At next date.
It has not been fixed for hearing.
It has not been fixed for hearing on the next date, but this has to be fixed for hearing.
The learned advocate appearing for the petitioner submits that no date for hearing of such application has been fixed. First of paragraph, CO number such and such stands disposed of by giving liberty to the petitioner to approach the learned trial judge with a prayer for fixing a date of hearing of the application under Order 7 Rule 11 of the Code of Civil Procedure. First up, if such a prayer is made, the learned trial judge shall consider the same and fix a date of hearing of the said application.
I'm under instruction. And I'm under instruction that despite making oral applications to that effect that Order 7 Rule 11 has to be heard, this has not been fixed for hearing. That is the difficulty.
That is why I have directed, please approach the.
At least for the Order 7 Rule 11 a time frame, and that is my only humble submission.
A little late, date be fixed. I've said
but the only thing, the date.
The learned trial judge is requested to make an endeavor to dispose of the application under Order 7 Rule 11 of the Code of Civil Procedure expeditiously. Yes.
But if a time frame is fixed, if
let a date be fixed, without a date being fixed, how can I fix a time frame?
The date, if a time is fixed, but probably
yes,
some.
Yes.
27, my lord, I appear for the petitioner, my lord, the order of the DRT is under challenge. Kindly, my lord, seize the order. Fundamental principles of law, my lord, have been basically thrown to the wind. My lord, kindly seize the order. Seize, my lord, 9/6/2026 is the order, my lord.
No, Mr. Bordon, please go.
I will. My lord, I will not persuade my lord to set aside the order. I would just be wanting a rehearing. And the reason is very clear, my lord. Kindly seize.
Rehearing for that also.
But he disposed of, my lord, at the interim stage, he disposed of the application. Kindly seize, my lord.
What application?
My lord, I challenge a sale as in by way of an interlocutory application. Now, my lord, the sale is fixed on 9th of June. I, my lord, move it on 8th. The other side appears and says there's an earlier essay. Both have to be heard together. Very good, my lord. On 9th, both the matters are heard together. My lord, kindly seize the last portion of the impugned order, my lord.
Yes.
As the sale process is on and the bid time starts from 3 p.m. today, the tribunal cannot unsettle the sale at this juncture. This is the finding of the tribunal. Thereafter, my lord. Therefore, I do not find strong prima facie case in favor of the applicant. And, my lord, may I say this? The sale.
From June 9, you could have challenged Mr. Bordon.
I appreciate, my lord, what I am on is, my lord, kindly let the DRT decide my application afresh without being swayed by this, my lord. He says, I do not find any prima facie case. Once he says, my lord, that the sale is on at 3 p.m. in the morning when I go to move, he says that he cannot interdict the sale.
It has been done.
It has been done.
No,
let the DRT, my lord, adjudicate the application once again, because what he has done is, my lord, kindly seize this. I do not.
What can be done? Sale has already been taken place.
If the sale has taken place and the DRT feels so, my lord, and it's the adversarial litigation, my lord, they are there. So, my lord, I'll add them as parties, but kindly let them consider the application afresh, because kindly seize what the DRT holds. I do not find strong prima facie case in favor of the applicant, hence is dismissed.
IA is dismissed.
That's my application. My lord, kindly visualize this. Well, what has been done, my lord? I'll tell you. There are two issues. One, my lord, infraction of statute. That I'll show, my lord, but I'll not trouble my lord with it. Because what has happened, my lord, on the day it issues the sale notice, it publishes the sale notice in the newspaper. My lord, that is against the law. The Supreme Court has held it. My lord, I'm not on that. What I'm on is, my lord, this is what the tribunal holds. It holds, I do not find any strong prima facie case. But admittedly, my application deserves to be considered on merits. Kindly seize, as the sale process is on.
Then, Mr. Bordon, all matters 227 has to be entertained.
No, Manad.
When there's an
effective
remedy, please go there.
I appreciate that. Manad, I for once, Manad, I would not want to persuade Manad to set aside the order. I am only on the proposition, my lord, let my application be heard on merits. Because what he has...
Mr. Bordon, for doing that, I have to set aside this order. That I cannot do without hearing the other side.
But then serves the notice, my lord. I know, my lord, I cannot be...
You can do a...
My lord, it will not. My lord, kindly visualize this. My lord, what happens is this, my lord. IA such and such stands disposed of, dismissed. So, my lord, my application has been dismissed, saying that I have no prima facie case. And
when an interrogatory application will be dismissed, the court or the tribunal will say you do not have any
No, my
prima
lord,
facie
I would
case.
have very well
After
understood.
holding that there's a prima facie case, cannot be dismissed.
Why balance of convenience and convenience? My lord, kindly sees the paragraph prior there too.
There's a
It's
prima facie case, why the balance of convenience?
my lord, what is the finding of the DRT? It says as the sale process is on and the bid time.
Mr. Bordon may be an expressive.
I appreciate, my lord.
All matters.
I do not want to challenge. My lord, I am not on the point of challenge, my lord. I am only on the proposition that let my application be heard out on merits. This is the only limited scope of my application, my lord. Let it be adjudicated. Otherwise, if I go back, my lord, this observation will stand against me.
No.
My lord, but kindly seize the remaining part of the order.
Bordon, you will be challenging this order before the appellate tribunal. Appellate tribunal will consider that.
My lord,
the order is set aside. All
my lord, kindly visualize this.
Even if not the observations
This,
can
my lord,
very
this,
well be
my lord,
expunged.
this I say is an exception, my lord, to the issue of, my lord, alternate remedy. It's an exception. And my lord, kindly sees what the tribunal does.
It's the discretion of the court whether
yes,
to.
my lord, it's the discretion of court, my lord. My lord, to that I have nothing to say. But my lord,
The discretion
I can
whether
only
to
persuade, my lord,
it or not.
I can only persuade, my lord, to exercise the discretion in this way.
The Bordon not in.
My lord, I appreciate.
I've entertained.
No, I appreciate.
That's
No,
a
I appreciate.
different,
I will not speak further.
was-
I'll not speak further. I leave it to your lordship. I leave it to your lordship.
In view of the alternative efficacious.
Lord, I've taken leave in this matter to move it today. Because Melody also asked me to serve the notice upon the corporation.
Corporation.
Yes, Melody, this is from the building tribunal sort of.
Yes, corporation.
Corporation I have served by post, but
Calcutta corporation.
yesterday it was a holiday. 19th is the demo.
Mr. Ghosh is there. Mr. Alok Ghosh.
No, Lord, I don't believe it's not more than. Well, it will reach by tomorrow. The difficulty is it will reach by today. Well, yesterday the attempt was made to serve.
So you
There was a
want it
holiday.
on Monday?
Difficult, may I only pray for a stay, my lord, for the timing. 19th is the.
Please bring anyone, Mr. Alok Ghosh, Mr.
This is coming for the first time.
Yes. Please.
I indicate what's there in the matter. I'll indicate.
Yes.
My lord, the petitioner is a very poor. She used to work at.
What is the order?
The order is in
illegal construction, demolition.
No illegal construction. I'll show, my lord. In the code, before the engineer, executive engineer, no notices were served. I said no notices were served on me. My lord, the order was passed for demolition. What was the construction? Constructed 170 square feet of tin shed. This was the construction that was alleged. Well, I got the 545, 546 notice. I assailed that notice. I take out a certified copy of the order. I assailed it before the building tribunal. I said that no notices were served on me, and I am a pre-existing tenant in respect of that room. That there was only one room on the second floor.
What the tribunal has done?
I'll say, my lord. I say there was only one room on the second floor. Entire second floor is a roof, and there was only one roof. And since 1950, there is a tenant. The court asked me, show me some documents. I filed the fair rent application, which the landlords has filed on me in 2011, stating that I am way back on my husband, stating that I am a long-term tenant. In 2011, the fair rent application from the court, which was served on me, I have annexed that. I said, see, there was 120 square feet space I am already occupying. And in the corporation, there was a sketch plan. In the sketch plan is showing that 70 square feet of space have been covered by a tin shed. Well, but I am occupying 120 square feet, and in the sketch plan it was shown that there is no more construction on the floor, on the entire roof. I asked the building tribunal to hold it in my favor and at least give me the opportunity to agitate before the executive engineer. But the entire thing has to go.
All right, please see whether Mr. Ghosh or anyone of his junior in front
So
of
I'll-
courtroom number 7.
Yes, will not.
Corner, you will be finding.
I have to find someone. If I can get anybody of the even from the corporation list.
Password.
Mr. I'll just say put a call. Great.
Yes, the password.
315. I indicate the time as 3:15. Today is 3:31. 3:15.
Please come within 5-10 minutes.
I'll try my level best.
Yes.
Lordship, I am for the petitioner. I am praying for not today.
Not today, next.
Obliged, Lordship.
My lord, I am for the petitioner, my lord, led by Mr. Parthapratim Roy. Mr. Roy is appearing virtually, my lord.
Yes. Why is he appearing virtually? He has stopped appearing physically nowadays.
No, my lord. He is out of station today only. My lord, this with leave of this honorable court, my lord, the revision was filed, and this is the certified copy, my lord.
Yes, what is the order under challenge?
My lord, that is order number 7, my lord, 20th April 2026, whereby, my lord, leave under section 12A was granted, my lord. My lord,
I am appearing on behalf of the other side. I am not served any copy of
there
the.
is no caveat, my lord, for that.
Please, sir.
My lord, only difficulty is this, my lord. 31st is the date fixed, my lord, for
21st.
31st. This 31st of this month.
All right, please, sir. I'm making it not today.
My lord, only difficulty on that day, my lord, the order was passed to that extent that, my lord, if there is no movement before this honorable court, my lord, the matter will be.
Please, sir, I'm keeping it on Monday. Yes.
Monday.
Next.
Great. Monday, my lord will be.
Bench will be there. No difficulty. Yes.
My lord, in that event, my lord, some protection, my lord. Otherwise, my lord, injunction application will be, my lord, injuncted, my lord. My lord, kindly consider if the matter is
merit
not
in my
taken up by-
injunction application, that means.
My lord,
That is why
there
12
that
leave
is a
was granted.
possibility, my lord. My lord, I cannot
Sir,
ignore that.
mention that if you have an urgency, mention it. It will remain in the list. Yes, call the next
Grateful
matter.
to that.
My lord, only this much, my lord. My lord, they have prayed for, my lord, time on account of to get the copy of this revisional application, my lord, so that if occasion so arises, my lord, I can pray for adjournment, my lord.
There was no caveat.
Caveat was there, my lord.
No caveat.
No
in
caveat
the-
was there.
When this matter is taken. Not today. Next.
In item number 36, my lord, I led by Mr. Shobhasai Chatterjee, my lord. He is on legs, my lord.
No, your lordship wanted to see the sanction plan.
Yes, Mr. Chatterjee, is it very urgent?
It's not. It hasn't been demolished, Milord, for about 30 years. I don't think it's going to be demolished, Milord, in the 2 weeks.
Not today then.
My lord, he is on legs, my lord. He is already.
Not today.
I have urgency, my lord.
Urgent.
But it should be demolished, my lord, otherwise.
Should be demolished. Should be demolished. I think.
My lord, I have
If there is
re-verified,
no-
my lord, my sanction plan yesterday.
You have said it should be demolished.
My lord, I said. He says, my lord, senior says.
You said that you should be.
No, I said, I stand corrected, my lord. It will be demolished, my lord. My lord, I have verified the sanction plan, my lord.
Yes.
This is the sanction plan, which is 3-storied building sanction was given, my lord. And 3-storied building, that is 4th floor, till it's there, my lord.
3-story
And-
and 4th floor.
Yes, I'm coming to that. My lord, the 3rd floor, which was initially demolished in 2006, lordship, kindly come to the order, impugned order
Where
once.
is the order of demolition?
Lordship, kindly come to the impugned order. It's part of that. I have brought the order of demolition also passed by the Lordship. It's in certified copy. Lordship, I will take your Lordship to the page internal, page 9. Page 9, 8.1. Internal page 9, BT Appeal 79 of 2008.
Page 9 of the impugned order.
Judgment, my lord.
Judgment of the tribunal.
Yes.
Page
My lord,
9.
Page 9. It's a long judgment, my lord.
23 pages judgment.
Yes.
Should not be set aside.
Has
to contain some reasons.
Lordship, kindly come to 8.
Otherwise, it cannot run to 23 pages.
Lordship, I come from that, and I'll try to satisfy your Lordship. It reveals some questions to be decided by this court, my lord.
Mukherjee, you are appearing for the corporation. Yes, we have got.
But kindly 8.1. After recording the detailed finding as aforesaid, the special officer building proceeded to pass the impugned order, which consists of two parts, namely, Part A, directing the person responsible to demolish the corridor and OT open terrace from first floor to top floor marked X in demolition sketch, and also demolish the entire top floor within 30 days. Part B, directing retention of other impugned unauthorized construction as shown in red color in this sketch, subject to conditions mentioned therein, including payment of retention charges. My lord, the first part, I have not made any appeal against the first part. Though I challenge the entire thing, my lord, the second part was the appeal against by which I am aggrieved presently.
Second is retention order.
Retention order. There was an order of retention, and retention order was conditional. Conditional, I paid the money, and I paid and deposited the money by virtue of an order passed by Honorable Justice Bishwajit Bosu, passed in a 227 proceeding, my lord. A civil revision was preferred, and his lordship was pleased to allow us to submit and deposit that money to the corporations we have deposited. So, lordship, so far that portion is concerned. Today, that portion is surviving. Now the question is, so far the implementation of the first portion. Now, this is the part A and part
to implementation. There is a writ pending in the other writ court. The other writ court, my lord, is in session of this matter with respect to implementation.
Implementation of this order.
Yes, sir.
So, my lord, now kindly lordship, kindly come to now what has happened. If your lordship take
the, what do you say? Both these are to be heard together.
It would be fair.
In that case, kindly protect us till for
Protection,
limited protection. It should be given.
Because the order, my lord, the other honorable single bench wants it to be implemented right away.
But there you have not disclosed
No
this.
sanction plan.
This was never disclosed.
No sanction plan, and this court has held that this retention is illegal.
Well, this is the sanction plan I have got.
That matter is appearing in the list.
My lord?
The implementation, the writ petition for implementation is appearing
in the list. They filed a CAN application which was rejected. In that implementation.
That writ petition is pending.
Yes, my lord.
So if the writ petition is pending
and
you want implementation,
yes,
and here he is challenging the order which you are trying to implement. Yes. So both these are to be heard. Technically, this is to be heard before that implementation.
I bow down. Also, I bow down. In a classical situation, it should have been heard together.
Yes, it can be heard together, but
also,
even if it is heard together, this has to be taken up first.
Also, yes, but I have no problems on that. The problem that I feel, my lord, it may lead to some sort of
conflicting decisions.
If
in that case, my lord, I have to be protected, my lord. Otherwise, your lordship has made a prima facie view that it should be heard before that is heard. Now that is for the implementation. This is the challenge. Lord, what has happened? My learned friend's client has not filed any cross appeal. Now my learned friend is
implementing the order of demolition.
Portion has been demolished. Now that happened only for
when your persons went.
That's been long back.
Not long back. Just the day when I filed it.
Lastly,
prior to that.
No, Kishan, kindly see the order of.
We will be visiting again to demolish.
The notice is on 24th.
When?
On 18 or 19.
Why is
18th of 19th of June.
Because my lord, matter was moved on 16th. The matter was adjourned because the point which your lordship is raising today, this was taken by me on the first day. Because my lord, they prayed for implementation order of the building tribunal. I said that when the matter was pending before the other my lord, judge, this matter should be heard. That has been opposed by practically all the parties. The matter was heard at length. Now, point for consideration was that whether Mr. Chatterjee's side, without preparing any appeal, but because my lord,
Which Mr. Chatterjee? All are Mr. Chatterjee.
senior Mr. Chatterjee.
But what has happened?
Senior Mr.
We made an application there. We prayed for the improvement.
Yes.
Let me see.
Demolition order was passed for 3 floors,
Usually.
and my lord, the retention order was passed for other portions.
Retention order is for other portions, and demolition is corridor and open terrace from first to top floor.
Now, what happened, my lord?
This has been partly demolished.
Yes, yes.
Now,
Fifth
what
floor
happened?
has been demolished.
What happened?
Fifth floor.
No, what happened against that order? Mr. Subusai Chatterjee's client prepared an act. Wherein that
Before
building tribunal.
Yes.
Why a piece was prepared? Because some portion has been permitted to retain, some portion was directed to be demolished. Against the order of demolition, he prepared an act.
Yes.
Now, in the appeal, although my cross appeal has been filed by Mr. Chatterjee, the senior Chatterjee client, but ultimately, my lord, demolition order has been passed. And not only the retention process, but also the other entire building was directed to be demolished. The point for consideration, whether without preparing any action, whether he can be double parties who prepared that. This was the point.
And I have judgments to say that he can be.
Let it be heard then.
No question of
You are
hearing.
equipped with the
Milord,
judgment, sir.
he doesn't have a sanction plan.
I
He
have a
had it-
sanction plan.
He had it
And
for
I
3
allege
floors.
that-
He had it for 3 floors. He made it, Milord, 5 floors. And then what he did?
Mr. Chatterjee, only one thing. He is aggrieved. He cannot be aggrieved by the retention portion.
No.
So he is aggrieved by the order of the portion which was directed to be demolished.
My lord.
His appeal is only with regard to that.
Yes,
and by that, the retention has been directed to be demolished.
Yes,
How can it be done?
Order 41 rule 22. No. Have a look at
Request
it.
to be heard.
Have a look at this. Have a look at it. দাঁড়া আরেকটা কপি দে
বলুন না স্যার
Yes, Mr. Chatterjee, I will hear this.
Milord, your lordship hears it, but gives me 1 minute's time to tell your lordship what is the problem.
Yes.
Milord, by this,
He cannot be Mr. Chatterjee. He cannot be made worse off in his own.
no, not worse off. Milord,
Yes, because he is challenging
Milord, this order
only a
of
portion which is
retention-
directed to be demolished.
I understand that. Milord, his order of retention is beyond jurisdiction. It's a nullity.
Mr. Chatterjee,
It's a
you have not.
nullity.
Mr. Chatterjee, you have not challenged
Milord,
that.
if it's a
So
nullity,
prima facie, I will hear you.
if it's a nullity, then
will hear
under
you.
order 41 rule 22, Milord, it's
I will hear you on that.
but
Order
the other
41.
portion has to be demolished, Milord. The other portion needs to be demolished, not the entire part. I understand the retention part, your lordship is saying, but the other part has to be demolished. Milord, with a 3-story building sanction plan, he has constructed 5 stories.
Yes, Mr. Chatterjee, I will be hearing that.
But
Yes,
for that, Milord, it needs to be demolished.
By
The other 2 portions,
order of-
other 2 floors, he can't keep it.
the order of the
When your lordship sees, my lord, the records, your lordship will find, my lord, what is happening.
No, one thing is what is troubling is one is
After
paying for
Deepak Mukherjee, my lord, there is nothing that can be done.
implementation and the challenge has to be hard
No,
together.
this order will have some reflection there, but that is not the one which is, my lord hears it. And there is a definite point of order 41 to 20. I'll show your lordship judgment on that, which says that you can get him worse off.
Yes.
Grateful.
Even without filing, my lord, the, I've
Yes.
given your lordship the judgment, but I'll
Grateful.
Yes. Yes. Have you brought
my lord, 37 has come wrongly.
37? Why?
Yesterday,
That
your
your
lordship
lordship was
was
pleased to fix it on 1st of August.
Hey, it 1st of August আছে 30. Yes.
It is on the 4th.
Yes, yes.
4 তারিখ করে দাও, আবার মুশকিল হবে।
4th.
Fifth.
Let it appear on 1st apatti. Yes, yes.
Well, nobody will come. Neither he is also praying for 4th.
No, he will be coming. Yes, din. Password ta din. Yes, who is for the corporation?
James Lordship.
Yes. Yes.
Keep it on Monday, Lordship. I will take the report, Lordship.
We'll take instructions.
Lordship.
No procedure till Monday.
Oh, no courses test till Monday.
There is an order of facing order of demolition. Corporation nowadays, Milord knows. That day I also did not object.
Within Monday will demolish.
19th it's going.
Maybe I have
19th self demolition is till 19th. Well, after 19th they just serve a notice of 2 days. I can show, Milord. They serve notice of 2 days.
The learned Yes, Mr. Banerjee.
Well, the other side was appearing yesterday. There was a Supreme Court direction, my lord. Well, they had
today.
given an undertaking. They had
Not today. Yes.
well, the execution is pending, my lord.
Yes. Next.
Well, the execution is pending. I cannot proceed.
That is
with
the other side, Mr. Banerjee.
Well, yesterday they were appearing. I have the affidavit of service. Yesterday, Lordship directed them to take instructions. All have been served. Advocate has been served also.
Instructions for what?
Lordship?
Instructions on what?
Instructions on why they are not vacating in spite of giving undertaking.
After that, they are not coming up with the instructions. Then I have to hear it on.
But this is the conduct. This has happened for the last 20, 30 days before the
Yes. Then file.
on a trial court. Detect the service. This was the previous direction.
Yes.
Pursuant to that, my affidavit is ready. Lordship will kindly come to page number 35.
What is the MCB's case under?
Police help application.
It's fixed on?
Malad, next fixed on 28th of July 2020.
Evidence completed.
Malad, 3 witnesses on the part of the opposite party. All have been completed.
Now it's for argument.
Yes.
Argument.
Yes. Again recall will come.
So now
again they will not argue.
This application under Article 220.
39.
The 39, my lord, my landed senior friend has served a copy to me, but the copies annexures are not in a.
Not today. Please give a better
My
copy.
lord, difficult is 21st is the date.
Yes, next.
Position may be retained, otherwise my lord, lower court date is 7, my lord, 7/1 has been rejected. So my lord, my position would be Monday, my lord, I may so get chance in my lord.
Taken on Monday, I am ready. I will do the matter. I do not want any adjournment.
My lord, if
What is the next date fixed before the trial court?
21st, that's why my Tuesday.
For hearing petition, my lord, not
For hearing of?
petition pending.
No.
application.
7/1 has been rejected.
Yes, but the date is fixed for hearing of petition.
Ex parte hearing.
No, my lord, not the hearing of petition. Well, I have checked.
Hearing of what petition?
Hearing of the pending application, the other
What application? 7/1?
Ex parte applications they have filed for taken up and the other application. But not is not for the evidence. The matter
My
is
lord,
not
my-
for the evidence.
All right, the petitioner will be. Yes.
Well, my lord, we appear on behalf of the respondents, my lord. Mr. Banerjee was uprising, my lord, on the last occasion, my lord. He's appearing online, my lord.
Yes. Yes.
My lord, I am assisting Mr.
Yes.
I'm sorry, my lord, I could not be there physically today. And
Yes,
unfortunately
Mr. Banerjee, how
occupied.
much time we will take? Because we will
This will
perhaps.
take some time.
Yes.
I can
So making it
only
not.
able, my lord, to conclude by 6:30.
But I was
Yes.
very.
But the
mixed up.
difficulty is, my lord, pendency of this litigation, my lord, is being shown before the learned
I
executive
am
court. My lord,
renewing
that's
my
the only
prayer which I
difficulty.
made
Mr.
yesterday.
Banerjee,
We are-
only one thing, this matter is being
Yes, my lord.
heard.
Yes.
They have concluded the argument. So I'm keeping
True.
it, please don't proceed with that in the meantime.
That is the only question.
I'm giving them liberty to pray for adjournment. I'm not passing any order of stay because I'm considering
My lord,
this.
my lord, I am here. I can understand. My lord, I am here to do the matter. My lord, even today, but I can understand, my lord, the time constraint.
Yes.
We have a
So,
resolution today. I can understand the time constraint. My lord,
yes,
we are
so I'm
agreeable,
keeping
my
it.
lord, to come back on 1st
So
of
I'm,
August also. I
yes,
don't
yes.
have any difficulty.
Yes, I'm. This matter will be retained in this position, so I'm only giving them liberty to pray for an adjournment. What is the next date fixed?
On
Tuesday, my lord.
21st.
My lord, then kindly
Ashwin?
allow us to come back on 1st of August, my lord.
Yes, yes.
1st of August, my lord, is
This
keeping
matter
some
will
of the
retain
matters.
its. This matter will be retained its position in the list on 1st of August. This matter will appear.
Very well. Very
well. Let the matter retain its position.
Is my lord?
Let the matter retain its position to 1st of August.
My lord is fixing a time on 1st, my lord.
Let it appear. Please mention.
Very well. I'm so grateful, my lord. So grateful.
Yes. Call the next matter.
grateful.
I'm for the My lord, I'm for the petitioner. My lord, on the previous day allowed me the opportunity to come back with necessary instructions. My instructions are twofold, my lord. Firstly, as per notice dated 13 July 26, the outstanding arrear is 1,95,386. The petitioner can scrape together 50,000 within the next 2 weeks after taking some loan. And the rest amount, if my lord allows some
I'm
installments.
keeping it on first. Yes, not today. Next. Yes. Call the next matter.
My lord, 42. My lord, this is, my lord, our matter. My lord, we need some relief. My lord, I'm praying, my lord, for a stay of the impugned order.
Yes.
My lord, may I just summarize before Lordship sees any papers? May I just summarize the case?
Yes. What is the
My lord,
urgency?
I had, my lord, adopted a girl child when she was 1 year old.
Where is the other side?
My lord, they were there earlier today, my lord. Now, my lord, at the time of call, my lord, they haven't.
You said you will be bringing your other side.
My lord, I got them, my lord. They.
Yes,
may I just, my lord, your lordship has also. Your lordship has also seen, my lord, that they have come, my lord, extreme urgency, my lord, and they will not, my lord, suffer any harm. I adopt.
Saying they will not suffer any harm.
My lord, I tell your lordship the facts.
Bring him.
My lord, may I just indicate the facts briefly, my lord? My lord, I adopted the girl child, my lord, when she was 1 year old. Today she's about 8 years old.
Keeping it on Monday.
Close to 9.
Maybe High Court will be there.
My lord, kindly just consider the difficulty. Can it be recorded that at the time of call, my lord, the respondents are absent? Because the caveat is absent. My lord, they filed a contempt, my lord, that
Yes, my lord. In this case, I am for the OP.
Not today, next.
I'm for the petitioner.
Cannot be finished.
Completely over part, man.
Well, I need a. I'm challenging, Malad. There's a expert. I'll just tell Malad in brief. I know it won't get finished. Malad, just take 5 minutes, then Malad, I'll come back.
That matter with Mr. Joyanta Mitra.
No, that's all right. Malad is aware. You don't have to. You also want to do the matter, Mr. Ray.
Wants to start.
Yes, let me, Malad, start.
Opening submission.
Yes, yes. Malad, I'll tell Malad what has happened.
And he closes today.
Malad, there's a.
We will not be closing today.
Malad, there's an ex parte ad interim order, Malad, which was obtained. Malad, we went up in appeal. Malad, wanting for a stay of the matter, which was not done. We have come in revision. Malad, the suit on the face of it. Malad, the suit on the face of it.
I have an application.
I can deal with it. I'm aware of it.
So that is something which I just put him on notice.
Malad, the suit on the face of it is a misconceived suit. Malad, I am Malad members of Malad in Malad. If I may use a simpler term, like a society. Malad, what has happened? This is Malad a syndicate where Malad members have come together to put in money and Malad to have Malad constructed flats for themselves. And this is Malad done Malad way back Malad in 62. They appointed a trustee. My learned friend's client Malad is the trustee. The trustee Malad is to look after, I'll show Malad all the deeds, is to look after Malad really the common area, but Malad the legal title is conveyed in his name because he is the trustee. I am Malad the beneficiary Malad under that. This arrangement has been continuing from time to time Malad. Also Malad there have been deeds, Malad supplemental deeds, which Malad defines more members have come in. Up to Malad 82 members came in by way of registered deed. After that Malad members came in, there was no registered deed in that sense. In now, as a trustee, he doesn't have any Malad right. He has filed a suit claiming interest, saying that the beneficial interest now should be conveyed to me. And also claiming for reliefs, Malad, against the interest of the beneficiaries. Now, Malad, two trust principles are very important, which Malad has to consider. Malad, first of all, he cannot act Malad against the interest of the beneficiaries. And Malad, I'll show the deed where Malad, by which Malad, the trust was imposed on him. That deed also has Malad some clauses. And it says the beneficiaries hold Malad, the flats, Malad, the allotted flats, akin to ownership. Now, he filed the suit. Obviously, Malad, now the ownership has changed. Someone else has come in. He filed the suit to say, I cannot exercise any right so far as Malad, my beneficial interest is concerned. On the face of it, Malad, I wanted to show Malad the trust deed. Malad, there was a deed prior to the trust deed, which my learned friend is saying that, oh, we did not disclose it in the suit. Therefore, you need leave under order 41. Order.
Well, that's not the point. Well, because he's not being instructed. I said there is an application pending for production of this document. You
are the trustee. That deed is
I have
referred to in
produced the trust deed.
Only one thing, Mr. Banerjee, miscellaneous appeal is pending.
Malad, I'm fully aware of it. Malad, it's a misconceived suit. Malad, this order, Malad, cannot stand even for a minute. Even for a minute.
So
I will show
if the miscellaneous appeal is directed to be disposed of because
Malad,
they have entered appearance.
I don't want to rush it. Malad, kindly give me Malad any day when Malad is back. Malad, kindly give me half an hour. I want to satisfy my lord. This order, Malad, could not have been passed. It's an ex parte ad interim order. He complains, Malad, from 82.
No, but only
says
only one thing. Whether I can in 227 set aside the trial courts when the
state. I have come for stay of the interim order, ex parte ad interim order before appeal. My lord has the power. My lord, I will show, my lord, it's a complete, my lord.
Ordinarily, Mr. Banerjee, it cannot be done, but in exceptional circumstances, it can be. It's
Otherwise,
not that.
my lord, I am only in revision because, my lord, I am aggrieved by the fact that, my lord, the lower appellate court or the first appellate court, my lord, has not exercised its jurisdiction in staying the order, my lord, ex parte ad interim order.
Yes, the application for stay or the prayer for stay was refused in the absence of the other side or in the presence of the, after hearing the other side. Both were heard.
Yes. Yes. Presence of the other side. I want to show, my lord, the suit on the face. I'm sorry, my lord, with great respect. My lord, the first court had, my lord, ignored the basic provisions of, my lord, trust law. Basic provisions. Can, my lord, with
the appeal,
can the trustee, my lord, apply? Trustee has no cause of action.
The appeal is ready.
My lord, the appeal, my lord, is not ready. My lord, I want to stay of that because, my lord, he cannot enjoy an order which, my lord, legally on the face of it, my lord, he's not
I am
entitled.
opposing my stay.
My lord, he may, my lord, he may.
I am showing also judgments at this stage.
We also-
I'm keeping it. If he
My lord,
gets a stay, that's allowed.
kindly keep it when my lord is back. I know my lord is not there. My lord, let's come back when my lord is.
Mr. Banerjee.
My lord, of the court, my lord, I will try and
retain its position in the list.
I'm so great. My lord,
When we come back on third.
my lord, retain its position, my lord, it is 44 today.
44 today.
If it retains its position, my lord, it will never, my lord, be called.
Retains this position means some matters have because Mr. Banerjee, only one thing.
Yes.
Some short matters are to be given
Yes, my lord.
precedence. Otherwise, the entire list will.
May I just make one submission?
No.
If it's on the third, my lord, kindly excuse me, my lord, kindly keeps on the
Let
sixth.
it appear on first.
Yes,
then,
my juniors will.
and if all of you are ready on first,
My lord, first, I would have, my lord, gladly come, my lord, I would have got some time. But, my lord, I'm personally, my lord, because of, my lord, I'm not here, my lord, my.
No. I was ready for the first.
No, you
Second
thought
time-
you just
no, no,
said.
unless he starts, you cannot make your submission.
Sorry, my lord.
Unless Mr.
That is
Banerjee
why,
starts, you cannot
but
make.
kindly allows my juniors to make that submission. I'm not here, my lord.
On
coming
the
because
third,
of-
my lord, can you keep it on the third?
Third and नहीं है।
तो ताले तो fifth है रखो, जो अभी तुम्हें आज।
Sixth है।
Sixth है रखो ताले।
Keeps it on sixth.
Well, can you keep it on the sixth? No?
Six.
Let the matter retain.
Same problem. First, I am in personal difficulty.
40 is what matter? That matter. Oh,
From 30th till 4th.
My lord, the only difficulty, my lord,
Even I will consider on that. You have made your submission. Reply I will consider. Let Mr. Banerjee conclude. Ask your juniors to remain.
Great.
Miss it.
But
You see the
Mr. Banerjee, because he was seriously opposing, that is why I have kept it on first.
I am ready, my lord.
You are ready. So ask your juniors to remain present for your argument. For your reply, I will be keeping another day. Because it might happen because these matters will be kept sometimes after 3:30. So maybe piecemeal. After Mr. Banerjee concludes, you may be giving a reply on another day.
Wait,